Supplementary list, fresh admission item number 1.
But item 1, I am there. I'm sorry that I am not physically present today.
No.
But in fact, I have filed an application for amendment, though I have challenged the virus of Rule 3. 6 of the
We'll allow those amendments. You say.
I'll file the consolidated in course of the day or by tomorrow. Madam.
All right. 8901. Since the petition is still at stage of admission, for the reason stated therein, the application is allowed. The amendments are permitted to be carried out. Then you say in the main writ petition, Mr. Mishra, learned senior counsel, states that the consolidated writ petition will be filed in a couple of days.
Right. But next week, if you bring this matter, I'll be ready to argue.
All right. Next Thursday.
But grateful, madam.
Supplementary list item number 2.
Item 2, identical matters have been placed to 16th November by your lordship.
All right. List on 16th November.
Oblige, your lordship.
Supplementary list item number 3.
Mr. Samal, where is he? There's a whole batch, no?
Please, minutes.
Item number 3.
Copy in this has not been received by us.
This is that rehabilitation scheme.
As item 3, minutes, the copy is not received, but item 5, 18, 20, and 21 pertain to the rehabilitation scheme, and it's a batch matter.
3, I think, is also that. Let me just see. Yeah. 3 is also that.
3 minutes.
Everything's, I think Mr.
The
Samal is a
defect number
huge
6 is there.
RAS batch. Yeah.
Let's make in 3 minutes, the direction may be issued to give us a copy, serve us a copy.
So the only thing, all these defects are still not removed. So that's why. All right. Just say, but what about those other matters? Just let's pass it over. He'll come.
Supplementary list item number 4.
May I please, your lordship, my lord?
Yes.
Opposite party number 4 and 5 illegally encroach the government land, my lord. Then President petitioner along with the villagers file a representation before the collector. Annexed 2, my lord. Kindly dispose of the representation, my lord.
All right. The petitioner's representation dated 5th November 2021 shall be examined by the collector.
Collector Baleshwar.
Collector Baleshwar, and after issuing notice to the petitioners as well as opposite parties 4 and 5, a reasoned order should be passed thereon not later than 5th September 2022 and made available to the parties not later than 12th September 2022. The court clarifies it has not expressed any view on merits. The petition is discussed. All right.
Supplementary list item number 5.
I mean, connected matter to item 5.
RAS, the rehabilitation assistance.
That the judgment should directed to only to verify whether the judgment is applicable.
Since it's the batch matter, my lords, it will come on the 27th of July. That is when
27 July.
27 July. That's when it will.
So in item 3 also the same issue.
Yes, my lords. Item 2.
So item 3, you say notice returnable 27 July. Mr. Mohanty accepts notice for the opposite parties. Copies of the paper book be served on him. Then item 5, what are the items? 5?
It's item 5, 18, 20, and 21.
Okay. All list on 27 July.
Lordship.
All right.
Supplementary list item number 6.
May it please the lordship. My lords, for better appreciation of this case, I would like, if your lordship may permit me, I'll take into the statute. The statute is Benami Transaction Prohibition Act 1988. I'm supplying the bare provision. Lordship will finally see, under the old act, the Benami transaction has been defined in subsection A to section 2, which reads like this. Benami transaction means any transaction in which property is transferred to one person or for a consideration paid or provided by another person. Then, my lords, in 2016, this act undergone significant changes that Act 43 of 2016 also I am supplying. Lordship may kindly see the definition in section 2A9. What is Benami transaction? Benami transaction means transaction or an arrangement. Now, this act has come into force with effect from 1/11/2016.
Yes.
Where a property is transferred to or is held by a person and the consideration for such a property has been provided or paid by another person, and the property is held for the immediate or future benefit, direct or indirect, of the person who has provided the consideration. Rest of it, my lords, is not relevant. Then Lordship may kindly see definition C, the next page. A transaction or an arrangement in respect of a property where the owner of the property is not aware of, or denies knowledge of such ownership. Then, my lords, he will be treated as a benamidar by virtue of the definition in subsection 10. Now, the beneficial owner is defined in subsection 12 to section 2. My lords, what has happened here? The petitioner before Lordship purchased shares, annexure 6, 6A, 6B at page 186 to 188 in the year 2014, my lords. Then, my lords, a search took place in the under section 132 of the IT Act before the in the office of the company from whom I purchased the share, my lords. Then a statement was recorded, that is annexure 7 at page 189, where I denied to have denied to have purchased the shares. Now, basing on this statement, a proceeding was initiated by the Deputy Commissioner of Income Tax Benami Prohibition Unit, that is annexure 1 at page 32, and the relevant page is at page 44, paragraph 7. From the above facts and circumstances, it is evident that the company Messrs. Alasore Marine Exports Private Limited has made investments in the shares itself in the name of Sri Biswajit Mahapatra for its future benefits only. Consequently, to escape the rigor of Benami Prohibition Property Transaction Act 1988, Sri Biswajit Mahapatra was made to transfer the shares held in his name with the company Alasore Marine Exports Private Limited to another company, Alasore Aqua Private Limited, which is a sister concern of Alasore Marine Exports Private Limited. Then, my lords, para 8, the Benami property has been defined in the property which is the subject matter of a Benami transaction, and also includes the proceeds from such property here. Here in this case at hand, the investment of 10,50,000 is found to be Benami property of Biswajit Mahapatra being the Benamidar. As such, the property has been transferred for a consideration of 16,80,000, taking into account of the market value of the shares as on the date of transfer. The enhanced value is 16,80,000 of the shares to be considered as the Benami property in terms of the provisions of section 2 bracketed 8 of the Prohibition of Benami Property Transaction Act, the section 2 within bracket 8 also came into force with effect from 1/11/2016. And the shares were purchased in the year 2014. Now he applied this retrospectively to the cause of action which arose in 13 and 14. My lords, that is the grievance here. The arrangement, the next para is para 9. The arrangement of declaring share deposits in the books of Alasore Marine in the name of 10,50,000 Biswajit Mahapatra, who denied such ownership in his statement recorded on oath, both under the provisions of IT Act, is a Benami transaction in terms of the provision of section 2(9)(c), which I have taken to your lordships few minutes ago, that any person denying the knowledge
becomes the beneficial owner.
Yes. And lastly, what he did, my lords, he, at page 46, what he did, Mr. Biswajit Mahapatra being the Benamidar for the investments of 10,50,000 the shares is prohibited to transfer the Benami property, that is the shares acquired in his name, to the beneficial owner or any other person acting on behalf of beneficial owner as per the provisions of section 6(1) of the Prohibition of Benami Property Transaction Act 1988. There exists no doubt over the fact that Alasore Marine Exports Private Limited or GR Das is the beneficial owner of such investment, and Alasore Aqua Private Limited has acted on their behalf, receiving the money, receiving the property.
So the shares are attached.
Shares were attached provisionally. Now, my lords, this was confirmed
by the adjudicating
authority. That is at page 51 and the relevant page is 182, where the order has been passed.
Right.
Now, my lords, so far as the retrospective application, whether the statute is retrospective or prospective, the Constitution Bench of the Supreme Court, in the case of Bhatika Ownership Private Limited, where Justice Sikri,
unless the statute expressly says.
Yes, unless the statute express, and the doctrine they evolved is the doctrine of fairness. When a right has already accrued to me, you cannot take away unless the statute expressly provides so.
Right.
Para 35, 36, 37 and 38 of the judgment.
Right.
Thereafter, my lords, the Telangana High Court on the very self-same issue, that is in Nexus Feeds Limited and others versus Assistant Commissioner of Income Tax, that delivered by Justice Ujjwal Lojha, my lords, Ujjwal Bhuiya, sorry. Those. He held that this definition, which came into force with effect from 1/11/2016, cannot be applied retrospectively.
All right.
My lords. Para 69.1 at page 52, your lordship will kindly see. Admittedly, these two provisions were not in the statute either on the date when the 1988 Act was enacted or when the transaction took place on 14/12/2011. It has been brought into the statute book by the amendment of Act of 2016. Question for consideration is whether the aforesaid definition can be applied to the above transaction which took place on 14/12/2011. Thereafter, the Honorable Court in para 70.
In your case, when did the share transfers take place?
They took place in the year 2014, my lords.
Okay.
A form of acceptance, lordship will kindly see at page 185 I have given. Then
you say all of this is prior to the date of the amendment.
yes. It cannot be applied retrospectively.
Anyway, notice has to go, I suppose.
Notice has to go and Annexure 3 is to be stayed.
Only one page.
No, but was there a stay because the order of the deputy
No,
commissioner-
that is a provisional attachment. under section 24, which has been confirmed by the adjudicating authority.
What is the value of these shares? Then you should not alter the.
And I will not alter. I will not alter. I will not alter. That is also the
status quo be maintained as to the shares.
Yes, status quo to be maintained.
You will not alienate the shares.
No.
All right.
So, my lord, only page 183. Appeal against the order.
Appeal tribunal has not been constituted. Time and again, Apex Court has said why you are not to the Union of India, why you are not constituting the
under the Act.
Yes.
I see. All right. The challenge in the present petition is to an order dated 28 April 2022 of the adjudicating authority under the Prohibition of Benami Property Transactions Act 1988 bracket PBPT Act bracket, whereby the provisional order of attachment dated 31st March 2021 of the Deputy Commissioner has been upheld and approved. Paragraph. One of the contentions of Learned Counsel, Mr. Siddharth Rai, Learned Senior Counsel for the petitioner, is that the share transactions in question took place in the year 2014, and the amended provisions of the PBPT Act, which came into effect from 1st November 2016, and in particular sections 2 bracket 9 bracket A, read with section 2 bracket 10 of the PBBT Act, have sought to be retrospectively applied to such transaction. Full stop. Relying on the decisions in Commission of Income Tax versus Vatika Township Private Limited, 2014 1 SEC page 1, and a judgment dated March 2022 of the High Court of Telangana in writ petition number 14695 of 2021 bracket Nexus Feeds Limited versus Assistant Commissioner of Income Tax. It is submitted that there cannot be a retrospective application of the amended provisions of the PBBT Act to transactions that took place prior to 1st November 2016. Paragraph. You say notice, Mr. Chimanka accepts notice on behalf of
Opposite parties,
opposite parties
2, 3, and 4.
2, 3, and 4. 5 and 6 are pro forma or?
Sorry, pro forma, because I have purchased this share. 2, 3, and 4, I will take notice so far as 5 and 6 are concerned, and extra copy I will serve on the Union of India. Notice also to Union of India, Ministry of Finance.
Right.
Yes.
So it is pointed out that opposite parties 5 and 6 are pro forma opposite parties, correct?
They are the beneficial owners.
So notice will go to them.
Notice has to go.
Notice be issued to them, returnable on 11th October 2022. Paragraph. Mr. Chimanka raises a preliminary
234
objection regarding maintainability of the present writ petition by pointing out that there is a provision for an appeal to a tribunal under section
46
of the PBBT Act. First of however, Mr. Rai, appearing for the petitioners, submits that till date, the tribunal in question has not yet been established, and therefore such remedy cannot be availed of by the petitioners. Paragraph. It is further directed that till the next date of hearing, the petitioner shall maintain status quo as to the shares in question which have been attached by the impugned order dated 31st March 2021 confirmed by the second impugned order dated 28th April 2022 of the adjudicating authority.
Obliged.
List on 11th October 2022.
7th of November, my lord.
No. 11th of October.
11th.
Item number
7 is also same. Sorry, 7 not same with 7. Yes. 7 is same, my lord.
Okay, same order.
Supplementary item number 8.
My lord. My lord, in this case, the petitioner, being agreed with the order passed by the opposite party number 3, a challenge before the ITT opposite party number 2 against the order of the opposite party number 3, that is Commission of Income Tax. When the matter stood thus, the Act has been amended with effect from 1/4/2021, wherein Section 255(7), 255(8), and 255(9) of the Income Tax Act has been introduced. The basic change of this same is that with effect from 1/4/21, there will be elimination of interface between the appellate tribunal and parties to the appeal in the course of appellate proceedings to the extent technologically feasible. And the second important aspect of introducing the same is at C, introducing an appellate system with dynamic jurisdiction.
No, 1 minute, sir. I'm not able to understand what you come to the prayer clause.
Prayer. That opposite part number 2.
1 minute, sir. Just read it. I'm not able to understand. By set aside, I don't know what. Just come to the prayer clause.
Set aside the order passed by the opposite.
No, you say by set aside. I think by is wrong, right?
It is ultra virus. This order is ultra virus actually.
No. Set aside the order. What is it? There's no date for the order.
My lord.
There is no date is mentioned with regard to the order passed by the OP number 2. Looking at the prayer.
There is no date is mentioned.
Yes.
See your prayer clause, sir.
Yeah. Why set aside the order passed by the opposite party number 2?
Where is the date? Which date?
Date is under Annexure 10. Annexure 10 is the order. I'm sorry not mentioning the order under Annexure 10. That has been passed on 2nd June 2022. Annexure
by
10,
whom? By whom?
By the Income Tax Appellate Tribunal, ITT opposite party number 2.
What is the opposite party number 2? Let's see.
My lord.
Come to your memo of party, sir. Cost title.
Sir, registered Income Tax Appellate Tribunal.
He has passed the order.
No, he has not passed the order because
you draft anything you like.
My lord, I'm sorry.
You better draft a proper petition. What is this way of carelessly? And I don't know. It doesn't make sense. By set aside. That's not even English.
My lord, I will amend this Annexure 10, mentioning introducing as Annexure 10.
No, but what is this? Why is he come in a writ petition against the ITT order?
No, this is the
because here challenge will not be order of the first appellate authority. The jurisdiction of tribunal has to only adjudicate the order. He is referring some notification issued by the government of India that why the tribunal has adopted and government has not issued the notification.
But anyway, it's an appealable order.
Yes, your lordship. That is what my
lord, let me submit that this notification is issued that no physical hearing is to be made with effect from 1.
That is not domain of the tribunal to decide this.
Let me complete. This notification is this.
You want to first file a proper petition? If you want to
I'll amend that. During the course of day.
But he also has an objection as to maintainability.
Under Annexure order passed by the Income Tax Tribunal under Annexure 10 that I will make today itself. I'll make today itself. Kindly allow to.
And the notification said the government may issue notification. Your lordship sees 7.
Let me complete.
And date is extended to 2023.
Let me complete then.
Then tribunal has passed the order and referring that we don't have any jurisdiction to redress this issue.
Yeah.
Only paras 1 to 6 are something about the jurisdiction of the IT-80. You're invoking a provision which has not yet come into force. That provision is going to come into force on 31st March. So this is a neat and simple appeal against the CIT's order under section 263.
No, my lord.
And the further remedy for you is to file an appeal here.
No, my lord, the question is that with effect from 2021, the tribunal is seizes its jurisdiction of...
No, sir, it has not been notified, sir. The provision
that is what
notified.
I'm coming. That is my case. That section 255(8) says that the central government, for the purpose of giving effect to the scheme,
correct,
made under subsection 7,
yeah,
by notification in the official gazette,
yeah,
direct that any of the provision of this act shall not apply,
right,
to such scheme or shall apply with such exceptions.
Correct.
Modification, adoption as may be specified in the said notification.
Correct. That notification has not yet come out, sir.
My lord.
That notification has not yet been
That
issued.
is exactly that. If this direction has to come, that even though section has been introduced, there will be exception to do physical hearing, whether in totality or in the specified case or in certain years. That direction has to be
anyway,
issued.
let that notification come. Before that, what is the point in telling the tribunal you cannot hear it physically?
That I have filed the petition. In reply to my petition, Commission of Income Tax has admitted that no notification has been made in this regard.
Correct.
He has also accepted that whatever I have stated is true.
Yeah.
But ignoring both the submission, the tribunal has proceeded to pass an order. Both the Commission of Income Tax and myself.
No, what is your problem? Why should they not hear it physically? I'm not able to understand.
2559 kindly have a glance of the said notification.
Every notification.
Every notice issued under section 7 and subsequent 8 shall, as soon as maybe after notification is issued and laid before the House of Parliament, it has not been issued. Then how is claiming that, this notice should be adopted by the tribunal?
That is exactly my case.
Then he has to approach the other not before the tribunal.
That is what I have submitted before the Income Tax Tribunal. If your lordship is of the opinion that we are not in the issue to decide, let it be referred to the central government or president of the Income Tax Tribunal.
IT has no such power to refer matters to central government.
Now, when the question of jurisdiction has been changed by virtue of introduction of the act, can IT, which is the creature of that...
So anyway, it's an order by the IT, correct?
My lord.
In an appeal. Further remedy is only an appeal.
Against the order, not the jurisdiction. This is the question of jurisdiction. They don't...
You're completely mistaken on that, sir.
My lord, only issue is here. In all the cases where this section has been introduced in the Income Tax Act, everywhere it is done. Exception to tribunal. Income Tax officer, joint commissioner, everybody suggests. With exception to this, they are not implementing it. My limited prayer is let a notice be issued to the central government. What is their opinion? Whether it will continue with the old section or this section is inappropriate. Let them give a reply. Because if the order will be illegal in otherwise, there is no going to, when the jurisdiction is challenged, how can it be appealed? Appealable is the order against the order, not the jurisdiction of the Income Tax Tribunal. That is why my limited prayer is let a notice be issued and whether central government is of the view to continue with the old scheme or with the new scheme with effect from 1/4/21. Because that is the purpose of the act. And to stop the interface, that act has been the government's sole intention and noble intention is to stop interface between the parties and the tribunal. That is where the case is.
Sorry?
This is about faceless tribunal also.
Yes, not yet. Government has not notified. How can it claim that government has notified? Then he has to approach this honorable court under 2 to 6, not before the tribunal. Tribunal has passed the order and the merit. And
Correct.
he has not stated anything about the merit of the case.
Correct.
I am not, my
That's what is not
lord, I
detailed.
have decided the case on this issue also at running page 42, para 4, 5.
So you can't split up like this, sir.
Yes.
You can't split up. All right. You say the present writ petition challenges an order dated to 2nd June 2022 passed by the Income Tax Appellate Tribunal, Cuttack Bench, Cuttack, bracket IT80, in dismissing the petitioner's appeal being ITA number 273/CTK/2015 for the assessment year, bracket AY 2008-9. Full stop. In the said appeal, the petitioner had challenged an order dated 9th March 2015, passed by the Commissioner of Income Tax, bracket CIT, bracket Bhubaneswar, under Section 263 of the Income Tax Act 1961, bracket Act, paragraph. Against an order passed by the IT80 in an appeal, the further remedy provided under Section 260, capital A of the Act is an appeal to this court. Full stop. Despite being aware of this provision, Mr. Sethi, learned counsel for the petitioner, insists that this court should entertain the present writ petition only because he had come up before the IT80 in the above appeal, raised the issue of jurisdiction of the IT80 to hear the appeal by contending that after the amendment to the Act
255.
But amendment to Section 255 of the Act by the Finance Act 2021, the procedure for the IT80 for hearing appeals has changed. Full stop. It must be noted that in the impugned order, the IT80 has disagreed with the contention of the SSC, petitioner SSC, by inter alia pointing out that the relevant provisions, that is sections 255, bracket 7, bracket 8, and bracket 9, although inserted in the Act with effect from 1st April 2021, have not yet been notified by the central government for becoming operational. And therefore, till such time, the existing arrangement of the IT80 hearing appeals had to continue. Paragraph. Mr. Sethi states that, full stop, it is further seen that this issue of jurisdiction has been dealt with by the IT80 in the impugned order from paras 1 to 6. And from para 7 onwards, the merits of the appeal have been discussed and the appeal has been dismissed on merits. Paragraph. Mr. Sethi wants to split up the impugned order by treating paras 1 to 6 as to jurisdiction separately from the rest of the order, and yet question the entire order in this writ petition. We'll stop. In the considered view of the court.
My lord, I am not questioning entire order.
This attempt
I am questioning the jurisdiction.
is misconceived. Full stop. With the impugned order of the IT80 being in an appeal before it, that entire order is an appealable one, and the further remedy of the petitioner is to file an appeal against the said order in accordance with law. Consequently, this writ petition is not entertained and it is dismissed on the ground of maintainability.
Supplementary list item number 9.
Please, your lordship. Lords, here, my lords may kindly have a glance to the last one. Please, your lordship. Lords, here, petitioner is a land outstay whose homestead land and agricultural land were taken over by the government due to the construction of the Ringali multipurpose project, wherein the petitioner is admittedly a displaced person. Lords, and if your lordship may kindly have a glance to annexure 1, With the rehabilitation policy, I was allotted either to choose from 3 acres of irrigated agricultural land and 0.5 decimals of homestead land, or allotment of 6 acres of unirrigated agriculture.
Mr. Paddy? Mr. PK Paddy? Mr. Paddy? You have now filed a counter affidavit. They have now filed a counter affidavit, sir.
No, my lord. Because we haven't received anything.
Mr. Paddy, you are on mute. Kindly unmute.
Mr. Paddy?
He
is unable to hear. Mr. Paddy?
Item 9, the Government of India.
Newly added.
Kindly unmute.
Number 5.
Kindly unmute, sir.
Yes.
Yes, Mr. Paddy.
Yes, my lord.
What happened? This Ministry of Environment Forest has to file an affidavit.
I'm sorry, well, I just.
No, writ petition 114 of 2003. Last time you told us
That's 25
that you had wrongly been informed that the counter was ready. You said you have yet to receive instructions in Ministry of Environment Forest.
My lord, Lakshmi, can pass over Mr. Behra is with the file. Can it be passed over?
No, it is not filed. Your lordship can grant them 1 week time to file, but they have not filed the counter affidavit.
I'll check it. Mr. Behra is with this file, my lord. I'm sorry, my lord. Can you pass over, or it can be adjourned to some other day?
No, we can pass over. We have no problem.
Yes.
Pass it over. All right.
Supplementary list item number 10.
In item number 10, your lordship directed me to take instruction whether this order has been complied with or not. My lord, Josh, now I have received the telephonic instruction that petitioner is not entitled to ISC paid scale of pay, so that for that reason that has been rejected. Direction was for consideration of his representation.
It can't be oral. Once a court issues notice, or notice has not gone.
No, my lord, direction was
went back in 2012. Notice was issued to you, sir.
My lord, here direction was issued to consider her representation only.
See, you have to file a show cause. Once a notice goes in a contempt petition, you have to show the least courtesy to the court by filing a show cause.
My lord, I am so sorry, my lord.
Everything can't be oral. So you will convey this orally to him. He is supposed to give an oral rejoinder.
My lord, your lordship may kindly grant me 3 days time. I will file a show cause.
I think on payment of costs. Because you're taking the court for granted.
My lord, as a
you're taking the court for granted. We do not like this.
My lord, as a last chance. Only 2 days time, my lord.
Counsel for the opposite party states that he will positively file a show cause affidavit in response to this contempt petition on or before 11th. Will you file it by Monday?
By Monday, I will file, my lord.
11th July 2022, failing which costs of rupees 5,000 shall be paid to the Welfare Association, the High Court Bar Association. An advance copy of the affidavit be served on counsel for the petitioner. List on 18 July. If the affidavit is not filed, the opposite party shall remain personally present before the court. Right.
Supplementary list item number 11. Item 11.
None appears. Dismissed for non-prosecution.
Supplementary list item number 12.
The petitioners have challenged the encouragement case. Encouragement case is pending for the last 10 years. One of 2012 is the encouragement case. Till date, no action has been taken. And
what's the encouragement case number, sir?
One of 2012 is the encouragement case.
Where do you get this?
My lords may see the last order, 11th of May 2022, my lords. My lords, we had to get instructions.
So what are your instructions, sir?
My lords, we had sent the letter, but instructions unfortunately hasn't come. I'll take a week's time, my lords. Next week, I will come up with the instruction with regard to the status of this encroachment case. That is the limited point. Because
Mr. Mohanty, learned ASC appearing for the opposite parties, seeks and is granted 2 weeks' time to comply with the order dated 11th May 2022. List on 25th July.
Supplementary list item number 13.
Grateful.
Number 13, my lord, day before yesterday, I have received a counter from opposite partner of 5 mallards.
What is the matter about? Let us see that, sir.
The matter with regard to the resettlement rehabilitation benefit, my lords, that was allowed, my lords, on 11 to 2014, 15. The writ application was disposed of, allowing the case in favor of the petitioner, my lords. Then, my lords, they filed a review application and review. The order was recalled, my lords, on 13/4/2022. The order was recalled. And notice was issued to opposite partner 5 mallards on 19/5/2022 mallards. And day before yesterday, mallards, the opposite partner filed a counter mallards, denying that the resettlement rehabilitation period I am not entitled to get mallards. For that purpose, mallards, just day before yesterday, I have received the counter mallards. So I want mallards 2 weeks time to file the rejoinder mallards.
This matter is already covered by your lordship judgment. It is a covered matter. Point of law is already decided by your lordship.
And another judgment, my lord, that is last case, my lord, that is another coordinate bench passed another order.
One more judgment. One more.
And I shall file a rejoinder, my lords, because
only question. Point of law is already decided. He is claiming that displaced, he may be treated as a displaced family for RR benefit. Because the government has issued a notification that a person who is not ordinarily residing in the area locality,
correct.
Prior to 3 years of the notification, he is not entitled. That is the law, and your lordship has already decided, and Supreme Court also in one case also government has issued a guidelines as regards to the RR policy.
And subsequently, my lord, that you are not
that 2 judgment is
subsequently, my lord, 24/6.
He has not filed the RR policy also, not annexed to the writ application.
24/6/2022, my lord.
He is not challenging that also.
24/6/2022, another coordinate bench passed a similar order, my lords. That is the for that purpose, my sir, I shall file a rejoinder. Just a day before yesterday, I have
Point
filed.
of law is only actually not disputed.
Yes. So there's nothing in this, sir.
Is it just, my lords, that is another coordinate bench, my lords, has passed the order, my lords. I have passed the order, my lords.
What is that?
That is filing 1138/2013, disposed upon on 24/6/2000.
It will all depend on the facts of every case, sir.
No, fact, my lord, that is, my lord, that is kindly glass to that is page 14, my lords. Page 14.
Yes.
Seventh line from the top, my lords.
Yes.
Now the moot question is whether such rights of the right flowing from the beneficial provisions of 2006 policy and its later amendment under article under Annexure 1A can be taken away by a circular under Annexure 3 when process of acquisition was initiated much earlier. It is well settled. It is well settled. Prospectively, while an operative circular has to be applied prospectively, and cited decision that is 2018-1 Supreme 1994, since the circular notification on Annexure 3 takes away the accrued rights of a category of displaced families and affected families under amended 2006 policy in getting the RR benefits, the same cannot be described as a beneficial circular notification. It can only be described as operative. Thus, such a circular can only have a prospective operation.
Even otherwise, Annexure 3 does not clearly indicate that it will have any retrospective operation. In other words, the circular under Annexure 3 can only apply to the purchase of the land and the notification made under Section 4.1 of 1984 Act after 2010, and it can apply to the purchase made by the notification under Annexure under Section 4.1 of the 894 Act. Prior to 2010, it may be noted that merely holding an Annexure 3 will apply to Section 4.1 notification issued under 894 Act. After issuance of Annexure 3 will not be enough, and the same still will have a retrospective operation vis-a-vis purchase made before issuance of Annexure 3, where Section 4.1 notification was issued immediately after issuance of Annexure 3. Therefore, the refusal of the authorities not paying the RR assistance to the late father of the petitioner bringing the product of the arbitrary exercise of power cannot be legally sustained. Additionally, also,
no, but there was no issue whether they were resident in that area prior to 3 years. That was not the issue in this case at all.
Yes, my lords.
No. Where is that?
Yes, my lords. That is, my lords. I have challenged that one. That is Annexure, my lords.
No. In the decision that you are citing,
yes,
this Goshiban Andar Nayak.
Yes, that is 2010.
Where is the issue of not being resident for more than 3 years? That is not an issue there.
Yes, my lord. That is, my lord. That is, my lord. That is at page 9, my lords. They have issued. They have given the circular, my lords. That is 2010 circular. Page 9, last portion.
No. That they were resident in the area for more than 3 years. Where is that issue?
Yes, my lords. That is at page 11. The perusal of the above noted clarification shows that clarification as contained in the third paragraph of the above noted notification makes it clear that persons or families who are ordinarily not residing or near the project area shall not be enumerated as displaced or affected families, and accordingly they will not be eligible to get the resettlement rehabilitation.
What is the date of your sale deed? 2007.
Yes. I could not answer.
No. The sale deed in your case is what? Dated 2007.
2007.
No.
They purchased the land between the transaction between the family only. Son, daughter, father. Purchased on 2/3/2007. And they said that in the writ application that they got the pata in the month of July. And got conversion in the month of July also. And since from the date of purchase of the land, they constructed the house. Their claim.
The cut of that
and it is out of imagination. There was, your lordship knows, under the OLR Act for conversion, minimum 2 months statutory period is required. But he created, and he also relied some voter ID card, which was first time introduced in 2009. That also I have that was subsequent event. That has nothing to do. Earlier judgment also, your lordship has reflected this. Regarding the
this judgment seems to say it cannot have retrospective effect. This 24 June judgment, have you seen this?
But the Supreme Court, it is not an amendment or new policy, it is a clarification.
No, that's right. But the bench of this court seems to disagree with that.
But the one coordinate bench, suppose this judgment was taken care of or not, I have not seen that judgment. Once the judgment was passed by another coordinate
Sujit
bench.
Kumar Sahu, have you?
Yes, I have gone through that judgment.
No, was that referred to in this judgment?
No, that judgment was not referred to, and in that judgment, my lords, that was not challenged. That was not challenged. That is the circular, my lords. But I have challenged that circular. That is prospective effect, and my lords hold that, my lords, at part.
Not circular, RR policy.
RR policy, yes. My lords hold, my lord, that is paragraph number.
RR policy was not challenged. Here in your case also, RR policy not challenged.
Paragraph 5, my lords hold that paragraph 5.
Relating to RR policy. It is not a new amendment or a new policy.
That is
it is just a clarification about the period only to misuse the.
Why has this matter come? Because it's a 2013 matter.
2013 matter, that was that.
No notice was issued, and this case was disposed of. I filed a review application, and because of without notice that was disposed of, it was recalled. First, earlier stage, no notice was issued to OP number 5. I am appearing for the OP number 5.
In this case, was notice issued to you?
No.
Oh. No, but this is a full. You have a copy of the judgment.
No, I have given the copy.
Give him a copy.
Only in another case, they have not given me that. completely
That was passed on 24 months yesterday night. My lord.
Copy maybe.
This judgment was disposed of in
24.
No. In the year 2022.
No, that's it. 22nd June 2022, sir.
Yes.
Not even 1 month ago.
And your lordship judgment is earlier to that.
I know, but did you appear in this case?
No. I have not appeared. Probably I am.
No, if despite notice you did not appear, then how can you?
But no notice was issued to me.
How do you know that?
But
that is not the Jindal Mal, that is Rengal irrigation
another
project.
Party probably.
That is Rengal irrigation project, and the state government was appearing.
He wants to file rejoinder. Your lordship, I want to hear.
No, but he's also relying on this, so you better get instructions on this judgment. You say cancel the petition. Give us back.
Lordship, if a coordinate bench in ignorance of earlier judgment and passed that, then my lord, I have cited the Supreme Court judgment in the case of a retrospective effect in electricity theft. Pending cases also it is applicable. In Supreme Court judgment, your lordship may kindly see that reported.
No, but that's in a different context altogether, sir. That judgment has nothing to do with land acquisition.
Land acquisition, my lord.
No, you better find out judgments concerning land acquisition, because this electricity theft matter and all will not apply here.
Whether it is a clarificatory in nature or amendment or a new.
No, you'll have to go into the wording, because this is a notification that's brought. This is not an amendment to an act. This is a
guidelines
Revenue Disaster Management Department notification.
My lord, your lordship may kindly turn to the
imposing additional conditions.
RR policy clause number 23. It is empowered to the state government if any dispute or doubt arises out of this RR policy, then the state government is the competent authority to issue guidelines, circular.
No, this residence requirement was there in the original policy.
But yes.
No.
In RR policy clause 23, I have annexed in my counter affidavit. He has not annexed the RR policy. RR policy, your lordship may kindly turn to page 20. Last page. Just I am reading that 23, clause number 23, my lord. Your lordship may kindly come to clause number RR policy. It is mentioned, my lord. Any issue or doubts regarding this policy shall be referred to government in revenue department, whose decision shall be final and binding all concerned. Government in revenue department may from time to time amend the provision.
I know. So the question that therefore is this notification of 2010 is the condition about being resident in the project area 3 years prior to the notification. Was it there originally or introduced only in 2010?
Not originally.
Come to the
1 minute, sir. We're asking him the question. Why are you getting up and answering?
Sorry,
So was this condition there originally in the original policy, or was it introduced for the first time in 2010?
Yes, madam. Now your lordship may kindly turn to the definition chapter of the RR policy.
So why don't you answer the question? The requirement that the person must be resident in the area for more than 3 years. Was it there? 1 minute, sir. Let me finish the question. Was it there in the original policy, or was it introduced for the first time by a notification of 2010?
It was introduced first time.
Sorry?
First time.
So the question therefore is, if it was introduced for the first time, will it apply retrospectively to transactions that have taken place prior to 2010?
Whether it is prospective and retrospective, it is the question of law. Your lordship.
You see, counsel for the petitioner relies on a decision dated 24th June 2022 of a coordinate bench of this court in writ petition civil 1138 of 2013, bracket Goshiba Nanda Nayak versus State of Orissa, where it has been held that the notification dated 20th October 2010 issued by the Revenue and Disaster Management Department, Government of Orissa, will imposing additional conditions for eligibility for benefit under the Orissa Resettlement and Rehabilitation Policy 2006 will not have retrospective effect. and therefore will not affect the transactions that have taken place prior thereto. Stop. Further, counsel to the petitioner states that the counter affidavit was received by him only 2 days ago and he needs time. Counter affidavit of opposite party number 5 was received only 2 days ago and he needs time to file a rejoinder there. Stop. Mr. Panda, learned counsel appearing for opposite party number 5 states that he will examine the above judgment and make his submissions on the next date. Rejoinder also be filed before the next date. 1 minute. Yeah. Since a view has been taken by the bench only recently, which decided writ petition civil 1138 of 2013, the court is of the view that this petition should be heard by the by the bench presided over by Justice B. Mahantiji, before whom it will be listed on the next date. Let it go before that bench. Then we'll have a consistent view, sir. There's no need to have a conflict of views.
There's a copy of the affidavit filed by OP number 5.
Copy of the affidavit filed by OP number 5 be served on counsel of the state. All right.
A date will fix must.
Already solved.
Given a date. List before the bench on. July 27 July.
It will be hard by that time.
That's right. That's
Supplementary list item number 14.
May I please, Your Lordship? In item 14, my Lordship, the petitioner who has been compulsory retired from the post of senior civil judge has challenged the order of compulsory retirement, Your Lordship. My Lordship, kindly see the last order dated 31st of March 2022. On that occasion, Your Lordship has directed the state to produce the entire service record of the petitioner.
It's been produced. You can open it. That whole.
Lordship, kindly verify the CCRs of 1989, 1990, 91, 93, 94, 98, 99, 2006, and 2011 and 14 that we have reflected in our counter affidavit.
Major, I have a humble request. My Lordship, before coming to any conclusion.
Yes, please.
Before coming to any conclusion, can I also peruse those records in the presence of the Deputy Registrar or Registrar of this High Court? Because I only know what they have alleged in the counter affidavit. I have also replied.
No. See, the point really is that there was a review committee which is what reviews this question whether the officer should continue beyond the ages.
My Lordship.
So we can tell you this, and I think it's already there in the counter affidavit. A disciplinary proceeding was initiated.
But my Lordship, it was not concluded.
No, it didn't conclude because by the time the review report, that report found him guilty. The report of inquiry found him guilty, but because the review committee was being held and it was already decided, it coincided with his reaching the age of 58. So they decided not to take that to the logical end. Otherwise, he was found guilty in the disciplinary inquiry. And the charge is quite serious.
Just for my satisfaction, Your Lordship.
Pressure to appoint a
Just for my satisfaction, Lordship, can I peruse so that I can
I
also
think you can
answer?
peruse it in the court here if you wish to. You can peruse it in the court. Mr. Mudali is here.
My Lordship.
You can peruse it in the court. Unless your client wants to see it.
That is the case, Your Lordship, because I have to be ready with my answer.
All right. The original entire service record of the petition has been produced before the court in a sealed cover. Full stop. It has been opened and perused by the bench. Paragraph. Learned counsel, the petitioner states that the petitioner would like to peruse it in the presence of a registrar of this court. Full stop. He is permitted to do so within the next 1 week in the chamber of the registrar judicial on a mutually convenient date and time. July 27.
Beautiful, Your Lordship.
All right. The report be placed back in a sealed cover and be kept with the registrar judicial for the above purpose. After inspection by the petitioner, it will be resealed.
Supplementary list item number 15.
Please, Your Lordship. Lord, I am in VC, my Lord.
Yes, please.
My Lord, on 19/4/2022, my Lord, Your Lordship permitted me to file a petition for amendment, my Lord.
Yes.
To include the affected parties, my Lord.
Yes.
I have already filed, my Lord, the petition, I am, my Lord, on 5/7/2022.
That is only day before, sir.
My Lord.
It's not come on record. You say, okay, you say the amendment application is stated to have been filed, be brought on record. List on 23rd August.
Supplementary list item number 16.
16 is over, I thought. This is also rehabilitation assistance.
Yes.
So already whole batch on to 27 July.
27 July. My Lord, along with my Lord, another matter, my Lord, 14,000, my Lord, kindly say 78. Sorry, 14,084.
So you better be clear. You write the number in a slip of paper.
14078 of 2000. Yes. That may be listed with that matter, my Lord, because on 29/6/2022, my Lord, it was in the list, but along with that batch matter, my Lord. But that was not referred to the 27 July, my Lord. So let it be listed along with that case, my Lord.
Or at least along with
14078 of 2024. Sorry, 14084 of.
So you just write down in a slip of paper. You're not clear about the number at all. You don't want the wrong petition to be listed.
My Lord, item 27 also the similar. Sorry, item 20 is also similar with my Lord and friend. This matter also taken up on 27 July.
18, 20 and 21 already.
Already this has been adjourned, sir.
Pardon me?
It has already been adjourned to the same date.
Along with 20419 of 20.
You have to write down whatever numbers you want, sir. Please write it down in a slip.
Yes.
Item 18 also same, item 18.
18, 20, 21.
18, 20, 21. Item number 17.
Get that slip. Prepare a note.
No, item 17, there are two matters. In the connected matter, recently I have received the copy. I will file the counter by tomorrow.
We see the second matter. Limited prayer is registration of the migrant labor at the panchayat level.
What about the central government, sir?
My lords, I'm appearing for the first
I know.
My lords, I think Mr. Pari has been on mute for 1 year for me.
Mr. Pari, please unmute.
As it appears from the noting that there is a counter by the opposite party number 1, that is Union of India, but I have not received any copy.
I don't think even we have not
No,
received.
not in my case.
In the past,
Not in Miss Padi's case.
yes, in the
No,
past
upper
matter,
party 2 and 3.
thereafter counter by OP1.
Which counter would be one?
Not filed.
Mr. Padi,
Yes, my lord.
that counter in the first matter, 15380. Not filed, sir, still.
Some time may be given, my lord.
This is what we've been doing all the time, sir. We've given enough number of adjournments. May, August, October, November, February, April. Now costs have to be paid.
7420.
It is. My lord, in 15380/2021, in that case, we have filed the counter.
When?
7/4/2022.
Where is it?
I have not received any copy. My lord, senior.
Nobody's received it, sir.
Then, my lord, sorry, our office may not. But there is a noting that they have, sir, we have an extra copy, another 1-2 copy. If required, then I make more.
No, even the court does not have it, sir.
Then I will check it up and I will file it, madam. Today I will check it.
Mr. Padi, Learned Assistant Solicitor General, states that on 7th April 2022, the Union of India has filed its reply in the present petition. It is not available on the file of the court or with the petitioner who appears in person or even the counsel of the state. Mr. Padi assures that the counter affidavit will be served on the above parties and also be placed on record within 1 week. What about the second matter?
Second matter, I will file the counter by tomorrow.
In 26786, Counsel for the State Government, Mr. Mudali, Counsel for the State Government, assures the court that the reply will be filed in 3 days with an advance copy to counsel petitioner who is permitted to file a rejoinder.
Yes, my lord, it was filed on e-filing mode. The original one is with us. Today we'll file it in the court.
All right. August.
Yes,
22nd August.
Yes.
No flash, my lord.
We'll say at 2 p.m. or at 2 p.m.
Supplementary list item number 18. Sorry, item number 19.
May I please, your lordship, may I be permitted to appear through virtual mode, your lordship?
Yes, please.
I am filing an affidavit on behalf of the commissioner. This relates to that municipal election of 2022, the RAM facilities, and I'm filing an affidavit. I'm giving because my line friend is appearing in a virtual mode. I'll serve a copy in course of the day to my line friend also, because he has filed an additional affidavit long back after the, of course, after the election was over. So.
So this is
Gajapati and Katak has made some.
Have you got a copy?
No, he has not got
a copy, Mr.
I have not given.
I will take it by today.
I'll give it.
Mr. Rautri, Senior Counsel, has handed over today in court the affidavit of the State Election Commission, additional affidavit of the State Election Commission. He states a copy thereof will be served on Mr. Sohail and Counsel for the petitioner during the course of the day. 29th August.
Deeply obliged.
By tomorrow, especially because he's appearing virtual mode.
All right. Within 2 days. All right. Within 2 days. All right.
Obliged.
Supplementary list for hearing item number 22.
May I be pardoned, my lord?
Yes, sir.
Can I pray, my lord, after last first case? I'm in a Pathar matter going in another court, my lord.
All right, at 2 o'clock. All right.
Supplementary list item 23.
23, my lord, after launch, my lord. Passover.
All right. All right. All right.
Item 24.
Yes, please.
May I please?
Yes.
Yes, there are three appellants.
Yes.
And three appellants are brothers.
All
and during pendency of the appeal, and he was on bail, one of the appellant has died.
Which is the appellant who has died?
Aurobindo Behera.
Abated. That's right.
And other.
There's only one more appellant, sir.
That's two more. Jaydev Behra and Govind Behra.
There are only two appellants. So the sole appellant now is Jaydev Behra.
Yes.
No, it's the three appellants.
Three appellants.
Jaydev Behra, Aurobindo Behra, and Govinda Behra. My lords, may I see the appeal memo at page 7.
That was criminal appeal. Here is the jail criminal appeal was filed first.
Oh, I see.
Then after that.
Right. In the criminal appeal. All right. All right. Okay.
I am for the appellant number Jaydev Behra. The one is for Govinda Behra.
Anyways, so all right, sir. Tell us what's the.
Here it is a daylight murder, and I couldn't at page 21. It was clearly enlarged that according to PW4, the doctor who has conducted postmortem report, is a homicidal death and hemorrhage due to mentioned injury and the time of death at the time of PM exemption 1825 hours.
Para 2, I think we can read para 2 of the Sessions Court judgment.
Yes, madam.
Trial court judgment.
The brief facts of the prosecution case is that on 9/10/1997, at about 10:20 a.m., deceased Gangadhara Paikrao was inside his medicine shop situated at Athagad, Patna, on the side of the road leading from Budam to Boirani, Kabisujya Nagar. At that time, one ambassador car came and stopped in front of the shop of the deceased, and from the said car, 7 persons, namely Aurobindo Behra, Jaydev Behra, present appellant, Govind Behra, all present accused persons, Munna Bholo, Surajya Das, Swadhin Das, and Balakrishna Naik got down and accused Aurobindo Behra, Jaydev Behra, Govindo Behra, and Suraj Das, Munna Bholo, each were armed with swords, and 2 accused persons, Balakrishna Naik and Swadhin Das, are holding 2 bags containing bombs. They all went inside the medicine shop of the deceased. Accused Surajya Das gave a sword blow aiming to the shoulder of the deceased, but the deceased warded the blow by means of his hand and sustained cut injury on his hand. And out of fear, the deceased fled away from the spot, from the shop towards the road in order to escape, and he ran towards northern side towards the house of Santosh Maharana. At that time, accused Balakrishna threw 1 bomb, but that bomb did not strike the body of the deceased. The other accused person chased the deceased armed with swords. At that time, 4 persons, namely Jagabandhu Behra, Pradeep Das, Surya Naik, son of Bhavani, and another Surya Naik, son of Bancha Naik, were standing nearby, were shouting, Pranare Mari De. The deceased fell down near a brick heap in front of the shop of Santosh Maharana. Then accused Aurobindo Behra, Govindo Behra, Jaydev Behra, Munna Bholo, Surajya Das gave blows to the deceased by means of swords on various parts of his body, and the deceased died at the spot. The accused person fled away, and after about 1 hour of the occurrence, police arrived at the spot, and PW1, the informant, lodged the FIR marked Exhibit 1, scribed by one Suresh Chandra Patnaik. Thereafter, PW2, PW12, the OIC Kabisujjan Nagar PS, finding prima facie case under Section 302 and 34 of IPC and 9B of Indian Explosive. PW1, 2, 3, and the eyewitnesses. PW1 is the brother of the deceased. I came to the FIR first. With 1 minute. Page 45. Of course, in Orissa, the FIR, he has mentioned that 11 persons, including these persons, and 4 others, has attacked the deceased and murdered him. Nothing about the role played by the present appellant. Then second para, it was mentioned this was witnessed by one Prafulla Pillai and others. He never said that I am the eyewitness to the occurrence. Then suddenly, in the evidence, he brought him as the eyewitness to the occurrence. And his evidence is at page 76. And he has mentioned the 11 names with, he is working in Surat last for 14 to 15 years. And he came to the, recently he came to the, before the murder, he recently came, and he has written all the names of the accused persons with their father's name. But at page 76, with the evidence of the para 3, I will come to. I know the accused person standing in the dock. My brother Gangadhar Paikrai was murdered on 9/10/97 at about 2:20 a.m. And at the time of occurrence, my brother was sitting inside the medical shop situated at Athawad, Patna, on the side of the road, and that road is leading from Budambu to Boirani. And at the time of occurrence, I was sitting at the shop of Dinabandhu Sethi and reading newspaper, from where he has seen the occurrence. But at page 125 spot map, there is no shop in the name of Dinabandhu Sethi. That was the spot map at page 124. Then at page 116, the IO has categorically said in the last para 14. My investigation revealed that at the time of occurrence, all the shops were open except Gorosau and Nasim Patra. I have not examined in local person of the spot. My investigation reveals that Santosh Behra has one grocery shop, but Dinabandhu Sethi had no shop near the spot from where he has seen the occurrence. That informant is saying. Para 14, last. Then, in the evidence, page 77, para 5. From the beginning. Then the deceased fell down near the brick heap up in front of the shop of Santosh Marana. Then accused person Aravindo Behra, Govindo Behra, Jaydev Behra, Munna Bhola, and Surajya Das gave blows to the deceased by means of swords on various parts of his body. And when I went to rescue the deceased, accused person chased me. The above said four persons, those who are standing nearby, were standing terrorizing the nearby shop owners, and all the shop owners fled away from the spot, closing there. He has told that I want to rescue him, but they have chased me and I went away. Then I take a pause for, then I go to PW2. Yes, Mayor.
No.
What is there in the cross-examination?
There's nothing in the cross-examination.
Yes. I page 82, para 22. I got it.
Yes.
I cannot say how police got the information. It is not a fact that Dinabandhu said he had no shop or house, and it is not a fact that I was standing near the house of Dinabandhu Sethi at the time of occurrence.
What is this? Nothing, neither here nor there, sir. This is something wrongly worded there. Anyway.
Specifically said that I am present there. Then I came to PW2 evidence.
No, so there's nothing else in the evidence of PW1 that discredits him, correct?
I want to doubt the presence of the witness. He has nothing said about the affair that I am the eyewitness.
All right.
I have seen the occurrence. He named another person.
All right.
Then he came to the picture that I am the eyewitness and I am seen all the matter from the Dinabandhu Sethi's house. Then second PW2.
Yes.
He was saying that he was a eyewitness.
Yes.
And para 1 at page 84.
Yes.
On the last line, on the above said that at relevant time, I was reading paper in the cycle mat of Santosh Maharana. She was present at the Santosh Maharana house, cycle mat of the Santosh Maharana. And she was at page 85, para 5. And he was saying, PW was also present and was sitting near Sethi's shop, and he has also seen the occurrence and informed the police. And that, and para 9, page 86. Santosh Maharana has one room which is used as a cycle mat, and at the time of occurrence, he was present in the shop. Santosh Maharana is also paper agent and he is a cycle mat owner, and I was reading paper. Santosh Maharana is also present there. He was as a charge sheet witness, but not examined. That proved that he was present at the time of occurrence, that PW was present. And he also saying that the PW was seen from the occurrence, Dinabandhu Sethi, where the IO has specifically stated that there is no shop of Dinabandhu Sethi. And all the witnesses are correlated. And he is the brother, and he is the PW2 and 3 are the friends of the
so he was in para 13. This witness was in judicial custody with Prafulla Polai.
Yes, my lord. PW2 and 3 are the friends of the person. Subsequently, they were arrested in murder cases.
So this is like some gang rivalry.
So many cases are pending.
The case of the defense is that they haven't committed the murder. There is another group called Pollei group. They have committed. But no positive evidence is given whether members of that group were present, whether they are the ones who have assaulted. There is also no suggestion.
So the Beheras, Pollais and Paikrais. All right. So they say Pollais are the one who killed the Behera.
Who have killed, but no evidence has been laid to show that whether they were present.
So these PWs 2 and 3, they were in judicial custody already for some Pollais murder.
For some Pollais murder. Unless the motive is clear, my lords, if my lords.
No, let him finish.
Please.
Then PW3,
No, you have anything to say, sir, on this witness, PW2?
That who was present was the Santosh Maharana, but Santosh Maharana is not examined. But he was charge witness, but not examined in the court to prove that he was present at the time of. They are
They all must be
friends.
scared to talk, sir. This is the whole problem. You come into gang war, you come into the witness box. Fortunately, this man is in judicial custody. This is actually witness protection. The only way to protect him is put him in jail.
No.
Otherwise, he'll be finished. The minute he's out, he'll be finished.
After this, this witness was taken to the judicial custody, and from
That's
where
right.
he came.
That's right. That's the only way to protect people, sir. It's a sad commentary on what the law and order situation is. Yes. No. So what else is there for you to attack this witness? Why should we disbelieve him? That's what you have to tell us.
The presence, whether he was present or not, he was saying that the PW was present at that time, and he has seen that Dinabandhu said. But I was
So
specifically
mere
said that.
doubting is not enough, sir. You have to show something, right? Doubting, one can always doubt.
Then PW, no other witnesses are examined. No.
Why should even one witness is good enough?
That should be related witnesses.
No. This PW2 is not related.
He is the friend.
He's a Mohanty, right?
He has the murder case with the deceased brother.
That's
and
all right.
deceased.
That's all right.
They belongs to one group, and PW3 is also the same. And he was saying that I am PW3 page 90. Para 2. On 9/10/97 at 10 am, I was coming by a bicycle to the medicine shop of deceased Gangadhar Paik Rai, and I found one ambassador car came from Budhar side and stopped in front of the medicine shop. Then he has spoken the, but in cross-examination first para, cross-examination para 12.
I cannot say.
I cannot say which shops are closed also. There are some residential house near the spot. There are more than 40 houses and shops near the spot, and people were staying in the residential house. Then when I reached near the spot, at that time the shopkeepers closed the shop and fled away. I cannot say the name of the shopkeepers. Yeah. That witness has reached the spot after the occurrence from the evidence. And he also said that I am working at page 17. Page 7, para 7.
What?
Para 7. Page 91. I was working as his watchman. I worked for one day. I do not remember on which day I worked under him.
So what?
He had gone to collect his dues. His evidence is he had gone to collect his dues. At that time, he saw the empire. But he could not say that for which day he is working, and one day and at that time he will go. He will go to collect that time. And also the para 12, he has said that when I reached the spot, all the at that time shopkeepers are closed and slop and fled away. And after an occurrence already happened, and all the witnesses are said that
it was still happening, sir. Not already happened. They were still chasing him with swords.
No, he has not said that he was chased by the accused persons or anybody. Only one has said that I want to save the deceased. All are chased him. Santosh Marana on PW2, where he is standing.
Why are you saying this? Para 3? Come to same page 91, para 3.
Surajya Das, Munna Bhola and Aurobindo Behra entered inside the medicine shop of the deceased. Then accused Surajya Das gave one sword blow on the shoulder of deceased, and when the deceased warded by his hand, accused Munna Bhola gave blow on the right hand of the deceased by sword. In order to escape, the deceased fled away through under the showcase towards road. And while he was running, the accused person chased with their weapons, and accused Aravinda Behera gave a blow by Kabadi Kati to the deceased. And
so why are you saying they never chase? He never talked about chasing. He's also talking about that.
He was the deceased was in his shop. As per the evidence of the PW 123 consistently said that the deceased was in his shop, and all the accused persons came by a car and attacked him inside the jail, inside the shop. And when he ran away, he was killed in the road. That was the evidence of all the witnesses.
Right. Chasing, that they were all chased. You just now argued that this witness has not said anything about chasing, which is not correct. You just now read para 3. He also talks about chasing. All the accused chasing the deceased.
All PW1 is when tried to save him, the accused person chased him to kill him. That was the version of the PW1. That's why I am told.
Anyway, what else?
And they are specific in that the accused persons came by a car, and the car was not seized. Neither.
Why should it be seized, sir? I don't understand. There's an eyewitness telling us the accused got down, entered the shop, first attacking the store.
Nothing about the mentioned in the FIR. They have
FIR is not an encyclopedia, sir.
Yeah, some clue must be there. No, only 11 names and 4 others. They tried to accuse many more persons, and police charged only 7.
So you still have to say why you were not involved. Whether others were left out or not is not going to help you, sir.
No, others. And that shows that the false influence starting from the affair.
All right.
Then he has said that I was present in the Sethi's house, but Sethi's house is not there. PW2 was saying that PW1 is sitting in the Sethi's house and she has seen all the occurrence. But where PW was sitting, that person was charged but not examined. Then PW3. And he was worked for 1 day, and at that time he has gone to collect the dues. And also said that when he reached the date, all the shops are squared. That means the occurrence have concluded. At that time, accused are squared. And then they never said that the accused person gone by that car or anything. And also, the swords which are recovered from 2 accused persons, not from these accused persons, they are not sealed, and the seizure witness are not examined. Although
that's it, sir.
And page 92, para 9, the case history of the three witnesses involved in as many as 5 cases. And this shows that they belong to one group.
Correct.
and they
Why
try
should
to
they be
implicate.
disbelieved is the question, sir. Why should they be disbelieved?
But they have not, the PW1 has not mentioned in the FR nothing. He has not
No,
even
2 and
said
3.
that
We
I
are now
am
on
the,
PW's 2 and 3. Why should 2 and 3 be disbelieved?
PW2 was saying that the PW was present and seen the occurrence from that Dinabandhu Sethi's house, which was not.
That is PW1.
Yes, my lord.
What is wrong with PW's
And
2 and 3?
And also also said that he was present at Santosh Maharana's house, and PW has seen that occurrence from Dinabandhu Sethi, which is not not proved by not correct by the IO that Dinabandhu Sethi's house has. There is no house in name of the Dinabandhu Sethi. That's why the PW also added the same story by PW1 and PW3, and then neighbor said that the PW1 has tried to save him and they have chased.
All right. Yes.
Because the defense is that another group, which is the Polei group, as the perpetrators. However, no evidence is laid, not even a stray comment is made that. So the factum of murder, my lords, is admitted. Now, my lords, PW1, PW2, and PW3 are the 3 eyewitnesses, and their evidence are consistent that a particular an ambassador car came in. The deceased was in his medical shop. The existence of the medical shop is also not disputed. It was only said that the documents were not there, but the existence is not disputed. The presence of PW1 is not disputed. Millards will turn to page 82, page 82 at para 21, where clearly Millards says that he was at this particular shop. And when he saw those persons come in, and then they first attacked the deceased, he ran out about 10-20 cubits he ran, so the adjoining shops. And in front of that, he fell because there was a bomb that was thrown. He fell, and then the accused persons came and they started attacking him with swords. And that caused his death. At that exactly at that time, they also intimidated all the others to go away from the spot, which is why, milords, none of the persons were there. The other shops were there, shopkeepers. And so and this continued for about 5 minutes. And then the PW1 came to his brother and saw that he was already dead. That is why he did not go to a hospital. And thereafter, the police was informed and the investigation started. PW12 is the IO, and the IO has also, and it is corroborated, the version of PW1, PW2, and PW3. Therefore, milords, there is no evidence contradicting the version of PW1, 2, and 3, which is consistent.
Yes.
PW4 is a doctor, milords. He has also been examined, the person who conducted the postmortem, and he said that all the injuries were antemortem and homicidal in nature. So the forensics part is also taken care of. And so finally, milords, the trial court, milords,
what was the motive for attacking this shopkeeper?
The motive, milords, will find that para 19 of the impugned judgment.
Yes.
Prosecution has proved the motive of murder through PW1, and he, in para 7 of his evidence, states that prior to 3 years of occurrence, accused Govind Behra, Arvind Behra, and Jaydev Behra and Balakrishna Naik were not staying in the village as they had quarrelled with the deceased and Punna Paikrai regarding the Sagar Bandha lease, and the said tank is situated in their village, and due to above said reason, the accused persons murdered his deceased brother. PW2 also at para 6 of his evidence states that prior to the occurrence of this case, there was a dispute regarding Mangaraj tank between the accused persons and the deceased, and he took the lease of the said tank from 1996. And prior to that, Orissa caste people were taking lease of the tank. PW3 also states the same fact that in the year of occurrence, Gangadhar and others had taken Sagar tank on lease for pisciculture, for which reason dispute arose between the deceased and accused persons. So, the motive is clear that there was some dispute there was a disagreement with regard to a lease, and thereafter they have come, because this happens in 1997, and from 1996 that particular pond is taken over by PW2, and PW1, PW2 are the deceased, and PW2 they were the ones who had taken the lease. So that was the motive for. And there was prior enmity, and with regard to Millard's related witness, the law is settled that the court has to just treat with caution when dealing with it and scrutinize it. There's a judgment of 2017 of Justice Deepak Mishra and Justice Nariman, which says that the distinguishing between the related witness and so I'll just place that judgment. I have.
Vijendra Singh.
Please, Vijendra Singh. Para 30 and 31 maybe. See. It is next contended by Mr. Giri Learned Counsel that all the eyewitnesses are related to the deceased so-and-so, and they are being interested witnesses. Their version requires scrutiny with care, caution, and circumspection. And when their evidence is scanned with the said parameters, it does not withstand so-and-so test. Page para 31. In this regard, reference to a passage from Hari Obula Reddy versus State of AP would be fruitful. In the said case, a 3-judge bench has ruled that it cannot be laid down as an invariable rule that interested evidence.
Yeah, you don't have to read the passage. All right.
Please, Manoj. Because it's worthy to note that there is a distinction between a witness who's related and an interested witness. A relative is a natural witness. The court in so-and-so has opined that a close relative who's a natural witness cannot be regarded as an interested witness, for the term interested postulates that the witness must have some interest in having the accused somehow or the other convicted for some animus or for some other reason. Plus, the reason why I'm placing it is because PW1 Millards is the brother, is a relative of the deceased. So therefore, Millards, he's a natural witness, and therefore, Millards, he will not say something so that the accused will flee away. That is, Millards, the inference.
Yes.
And with regard to non-examination of the material witnesses also, Millards will see at para 35, where again, contention was taken that some material witnesses were not examined. So the court has relied on state of Himachal Pradesh was Gyanchand's case, Millards. The non-examination of a material witness is again not a mathematical formula for discarding the weight of the testimony available on record, however natural, trustworthy, and convincing it may be. The charge of withholding a material witness from the court leveled against the prosecution should be examined in the background of the facts and circumstances of each case, so as to find whether the witnesses were available for being examined in the court and yet withheld by the prosecution. The court, after so holding, further ruled that it is the duty of the court to first assess the trustworthiness of the evidence available on record, and if the court finds the evidence adduced worthy of being relied on and deserves acceptance, then non-examination of any other witness available who could also have been examined but were not examined does not affect the case of the prosecution. So, Millards, in this case, Millards, as far as the evidence of PW 1, 2, and 3 is concerned, it is consistent and there is no ground for disbelieving the same. So therefore, Santosh Marana being examined or not being examined doesn't really change the course of the.
Here is the motive. Motive is that there is a difference between the taken to the Sagar Bandh. Sagar Bandh, where is the pisciculture is going on, that that was taken by the accused too, witness number 2. But that document has been not seized or not proved by the prosecution. And second thing is non-examination of the independent witnesses. They have examined PW 5, 6, and 11, and they are turned hostile. And page 116, the IO's evidence is that my investigation revealed that at the time of occurrence, all the shops were open except Gaurasau and Narsingh Patra. And Narsingh Patra was examined as PW 11 and Gaurasau was examined PW 6. Others whose shops are open, they are not examined. Santosh Marana is not examined. Only these 3 witnesses come to the came and said that these persons are killed the deceased.
All right. PW 6 was in fact examined, but he's been declared hostile.
Yeah.
But his shops are not there.
All right. Orders reserved.
My written argument and all listen.
All right. All right. All right. Orders reserved.
Item number 25.
25 notice was issued for personal appearance of the appellant.
Is there?
Sir, mo kilo mori ayanti mote no akilo dewa lagi chahuji mu.
No, we'll engage. Tell him we'll give him a legal.
Adu hafta samay diyantu.
ଆମେ ଗୋଟେ legal aid council engage କରିବୁ
ଆଜ୍ଞା
ସରକାର ତରଫରୁ ଓକିଲ ଦବୁ
ଆଜ୍ଞା
So who is appearing for the High Court Legal Services Committee?
Mr. B. Panda was
B. Panda has expired.
No. Last time we already appointed a legal aid counsel, sir. Where is he? His name shown in the list. Where is he? Yeah, already engaged. Just ask him to wait. Just call up the Somyak. Ask him to get the Somyak Ranjan Jana to the court. He's not appearing. Passover. Just ask him to wait. No, Mr. Katkia, kindly ask him to wait.
ଆପଣ ଟିକେ ଅପେକ୍ଷା କରିଥାନ୍ତୁ
Page 26 also, since nobody appeared on
I think we've already appointed counsel.
Yes. You want to engage me, Lordship?
No, sir, we have already appointed a counsel for him. He's already been appointed. A counsel we have appointed for him.
I allow Lordship along with my Vinam only to assist.
Ask them all. Tell Mr. Samyak Patra they should send. What is this happening? Why have they not appearing? Please ask him to wait in the courts.
Lordship.
Kindly ask him to wait in the court. Yes, Mr. Panda.
Lords, in 27, Mr. Sahu is appearing for the appellant number 1. He telephoned me today in the morning and said that today is his mother's Shraddha. So he will not be able to argue for appellant number 1. I am for the other appellants. Can your Lordship call it in the last week of August? We can do it.
Why last week, sir?
Of July. Last week of July. Lord, the other 2 weeks I am busy in sessions the next 2 Thursdays.
Or at 28 July.
My
Mr. Sahu appearing for appellant number 1 is stated to be in some personal difficulty today. Mr. Panda states he's in difficulty in the next 2 weeks. List on 28th July.
Item 48.
Appellant is present, Lords.
Who's the counsel you've appointed?
May I will, my name is Suryakant Das Mahapatra, my lord. I have appointed the legal aid.
Yes.
And I have received the brief 2 weeks before, my lord. I prep some time to prepare.
No, sir. Please. At least carry on. We'll pass it over. Get ready with the matter.
At least, my lord, 1 time.
No, sir. Sorry. You are legal aid counsel. You're not here to ask for adjournments.
My lord,
very sorry. We gave you enough time. You got the paper book for 2 weeks. This is not a very difficult case. We will call it after lunch. You better get ready with the matters.
My lord, at least 2 weeks.
Sorry. You just get ready with the matter and come after lunch. Yes.
Item 49.
No, sir. It's a government appeal. Lords.
The government appeal, I am appealing for the respondents. It came up in the supplementary list. I have not collected the paper books. Let it also come on the 28th of July. It's an appeal against acquittal, Millers, not urgent.
Sir, everything can't be adjourned, sir. Mr. Panda, you're here today.
Yes,
we might as well make use of your presence.
Paper book, Millers. I don't have the paper book. I haven't collected the paper book. I was not aware that it will be listed. I am respondent, and there is a revision also along with it. So I am saying 28th, Millers.
All right. At the request of Mr. Panda, list on 28th. So please, whatever you have to do, you do, sir.
Yes,
let's not adjourn it again and again.
Ready, Millers, in both the matters. I am ready in the other matter, but because of Mr. Sahu's difficulty. In any event, I have got matters in the weekly list also.
Number 30. Good. All right.
Lordship, I pray for some time, Lordship. Can you take up next week? I will do this.
No, madam, just get used to the idea. We are not sitting here only to grant adjournments. We are here to hear matters.
Lordship, last time, next week.
No. There is no next week, this week. You better get ready. If you want time, we'll take it up after lunch. No adjournments. Better get ready with the matter now. Yes.
Item number 31.
After lunch.
Why can't you argue now, sir?
My senior, my lord, argue this matter, my lord.
Who's your senior, sir?
Samir Kumar Mishra.
Sorry?
Samir Kumar Mishra.
I see. All right.
Pastoral matter, item number 9. Supplementary list, pastoral matter, item number 9.
Please, your lordship.
Yes, Mr. Padi. Mr. PK Pari?
Yes, my lord. Yes.
What happened, sir, in this item?
That item, my lord, I checked it up. We didn't have any instruction wrongly. Might have Mr. Behra submitted on some other case. He get received instruction, but he has wrongly submitted. We have not received any instruction. They have sought for a read petition copy, legible copy of the read petition. We have received an instruction from them. They want a legible copy of the instruction. If the my lord friend will supply them within a week, I will send it and will get the instruction with the right.
May kindly have a glance to the last order. It was very clear that they did not speak about anything about the legibility.
Correct.
So,
my lord, last
7 to
petition,
22.
I am admitting that Mr. Behra is wrongly submitted that we have taken instruction. Some other case.
Look, Mr. Behra submitted on 7.
Which part of the petition is not legible, sir? Because whatever we have, it's all legible.
But my lord, what happened in this case? We have implemented as a party as a OP number 5, my lord. I've checked it up. Then only I send it immediately. It was send it for the department.
No, which part of this petition is not legible? That's not clear to us. Whatever you have, is it legible to you or not?
I have that copy. It is some 2-3 pages are not clearly legible. Otherwise, petition copy.
Which page is not legible? Tell us.
Now you can manage it from the LMS level. We are getting it, so you can send it. Let's give more time.
Mr. Padi seeks and is granted a last opportunity to file an affidavit on behalf of the MOEF CC. You say Mr. Padi states, Mr. Padi's ASGI states that due to some miscommunication, the affidavit of the MOEF CC could not be filed. He assures the court it will be positively be filed on or before 22nd August 2022. 12 September.
Lords, may I pray just one thing, Lords? It's a very small matter, very on Lordship. If you kindly glances to the Annexure 6, it is pertinent, Lords, that I was a displaced person, Lords, and I was allotted a land under the government policy, Lords. That land, 2 of the plots were found to be reserved forest. That is where the question arose.
Correct. That's
Lords, and I am still there. I am 85 years old.
I know. We'll just wait till 12th September. That's all. All right.
My lord, 1 to 8 page is not complete. It is an old type copy. It's not a computerized copy. It's a typed copy, and it was completely hazy. So if my lord friend will help me for giving the copy.
May I pray the registry may be directed, because even if I serve, it will not be able to.
The copies which we have, they are in the same condition.
Yes, my lords.
It also, my lords.
We're not concerned about these things, Mr. Pari. Now you can have somebody retype it and send it.
Yes, madam.
All right.
I'll do.
Right.
Oblige, Lords.
Yeah. Start the weekly.
Weekly list. Old matter item number 1.
Hey, please, your lordship.
Yes, please.
I will back. My lord, item number 28. I'm sorry, 23 in the supplementary list, which my associate has taken time for after lunch. Take up this matter and other matters maybe.
If you are prepared to argue it now, do it, sir. We are here.
Yes, ma'am. Item number
28. All right, sir. Good. All right.
23 supplementary matter. 23. That's not 28.
23. Okay, whatever.
When the matter was called, my associate has asked for after lunch.
No problem, sir. No problem.
After lunch, now I have some problem.
Hemant Kumar Patel.
Yes, ma'am.
Right, sir. Let's please start.
Here, my lord, 2 appellants have been convicted under section 302 by 34 IPC, 302 by 34 IPC, my lord, and also 323 by 34 IPC, and for 302, my lord, life imprisonment, and for 323, 6 months, my lord. It's a case, my lord, where these 2 appellants, it is alleged that these 2 appellants, the father of the informant, my lord, who has been examined as PW8, my lord, is the son of the deceased. His case is, my lord, his father was drunk, my lord. He had gone to his workplace, anticipating that he may not come because of his, my lord, because he was drunk, my lord. He went to bring back his father. And while he went to bring back his father, my lord, during evening hour, my lord, they were coming back. The father, the son, they were coming back. And another, my lord, his uncle, they were coming back, my lord. At a particular place, my lord, he was attacked by these two accused persons. They were at, while, my lord, the deceased embraced him by saying that my grandson, embraced. This is a prosecution case, my lord. Immediately they took it, my lord, and they attacked, my lord, open attack, as a result of which, my lord, this informant sustained injury because the attack is by means of a torchlight. He sustained some minor injuries, my lord. Then, my lord, thereafter they went away, and it is alleged that again they came with the two weapons, my lord, and assaulted his father, as a result of which his father died, my lord, at this spot. And therefore, my lord, a case was registered and charge sheet was submitted under section 302 by 34 IPC, my lord. This case, your lordship will find, I have also filed a written note of submissions, my lord. Maybe available, I have mentioned everything in my written note of submissions, my lord. Your lordship will find that this case is based solely on the statement on the eyewitness version of PW7, PW7, 8 and 9, out of which PW7 has turned hostile, and PW8 and 9 are the witnesses who has supported the prosecution case, and on the basis of whose statement, my lord, the appellants have been convicted. So for PW8 and 9 are concerned, PW8 and 9 are concerned, my lord. 8 is the son of the deceased, and 9, Lakshman Oram, is the brother of the deceased. Both of them are eyewitnesses, my lord. Interested witness in the sense that one is the son or the brother, my lord. My lord, argument is not that the interested witness should be thrown out, because my argument will be, my lord, the other witnesses are there, they have not supported. Even their own relations, my lord, other witness, my lord, PW7 and other witnesses, they have not been examined, and those who have been examined has not supported the prosecution case, my lord. Admittedly, the incident had taken place in the night hour, my lord, when it was raining. Your lordship may kindly see judgment, my lord. My note, it will be better, my lord, if your lordship will refer kindly to my note. I have already submitted, my lord.
Yes, we have it, sir.
My lord. Will your lordship permit me to place my note?
Yes, please.
My lord. This appeal is directed against the judgment and order that 24/2001 passed by the Court of the Additional Sessions Judge Jharsuguda. By the impugned order, the trial court has convicted both the appellants under section 323, 302 IPC, read with section 34 IPC, and sentenced each of them to undergo RI for life for the offence under section 302 by 34 and RI for 6 months. The prosecution case has revealed from the first informed report, Exhibit 8, lodged by one Dubras Oram, PW8, at Kolavira Police Station, Jharsuguda, is that on 29/12/96 on Sunday evening at about 7 to 7:30 p.m., his father, Saheb Oram, since deceased, had gone to Koleri, Rajanaragar for labor work. Since he was not able to come back, the informant has gone to bring him back up to the house of Kirtana Nayak, PW3, at about 8 p.m. When the informant and his father were running, they met both the appellants. The deceased embraced the appellant number 2, saying, grandson.
Embraced must be.
Yes, man, embraced. Embraced. No, that's not embarrassed. Embraced the appellant number 2, saying, grandson, Nati. Grandson, mine also for son's son. Right. In Odia, it is a Nati. He said Nati. Right. English is grandson. Nati, grandson, being enraged, both the appellants assaulted him by fist blows and kick blows. The informant who was attending the call of nature immediately went to separate them. Appellant number 1 assaulted him, PW8, by means of a torch, and Lalit deceased, and Lalita tussled with him. At that time, Grahan Oram, PW7, who belongs to the same Poda, intervened and separated them. Due to assault by torchlight, the informant sustained injuries on his forehead and his index finger. Thereafter, accused Lalit and Hemanta went inside the village, and the informant and the deceased were returning to their residence. at about 8:30 p.m. my lord. That's 1 hour after the incident, 1 hour after the first incident, 8:30 p.m. Both the appellants, being armed with one tangi, ran towards them. The informant suggested his father to run away from the spot. Thereafter, both the appellants assaulted by means of their respective tangi on the head of the deceased, as a result of which the deceased fell down. Being afraid of the informant, concealed himself in an amori bush. Thereafter, both the appellants dragged his father, deceased, towards a mohulo tree and threw him there, and they both went towards Telubandha. While his father was being assaulted, his uncle Gopal Oram, not examined, my lord, and Lakshman Oram, elder brother of the deceased, examined as Peter 9, had seen the incident. Thereafter, the informant and the villagers, namely Kirtana Nayaka, PW3, Ramakrishna, PW5, went to the spot and found 3 bleeding injuries on the head of the deceased, and the thumb and the middle finger of the left hand of the deceased were detached. At the time, the father of the informant was gasping, and the informant brought water for his father, but he could not drink. They brought the deceased to their home, and in their home, the deceased died due to the late night being afraid of forest animals. He lost the affair on the next day. Affair is marked as Exhibit 8 at page 55 of the paper book. That Schedule 12, the SI of police of Kolabira police reduced the oral information of Schedule 8 into writing, registered the affair, and took up investigations of the case. He completed the investigations, and after examination of witnesses and collecting materials, submitted a charge sheet against the appellants under section 341, 323, 302 by 34 IPC of the Indian Penal Code, read with section 32 of the SC/ST Act, that both the appellants, after being committed to the Court of Sessions, were charged under section 341, 323, 302, 34 IPC, read with section 32 of the SC/ST Act, that the plea of the accused persons was one of the complete denial of the occurrence. Specific plea of the accused Lalit Oran on 29/12/96, the date of occurrence, he was on duty as a guard in the District Intelligence Bureau. While he was a police constable, and at that time he was attached to the DIB, and the office was the office was in the SP office, attached to the office of the SP, and functioning his duty as a resident office of Superintendent of Police of Jharsuguda. That prosecution had examined 16 witnesses in all. Out of the witnesses, P8, the son of the deceased, and P9, the brother of the deceased, were the eyewitnesses. These are the 2 eyewitnesses, my lord. Other witnesses, although present, they have not been examined, and those who have been examined have not supported. Eyewitnesses to the occurrence. P1 was the constable at Kolabira PS, who escorted the dead body for autopsy. P2 is the witness to inquest, and who leading discovery. Unless weapon of offense. P3 is the co-villager who did not support the prosecution case. P4 is Gramarokhi, witness to FR. P5 is a co-villager. He did not support the prosecution case. P6 is the seizure witness of the accused Hemanta Patel, so wearing apparels. P7 is the co-villager who did not support the prosecution case, and P10 is the doctor who conducted the PM examination, Exhibit 9. P11 is the co-villager who did not support the prosecution case. P12 is the IO who investigated the case and submitted the charge sheet. P13 is the Reserve Sub-Inspector of Jharsuguda. P14 is the confidential reader attached to SP Office Jharsuguda. Both of them have deposed about the absence of appellant Lalit Oram on his duty. P15 is a witness to leading discovery, but he did not support. P16 is the doctor who examined the injured. P8, 2 witnesses were examined on behalf of the appellants. Lalit Oram, P1, Arun Kumar Sethi is an ARP constable who was a colleague of accused Lalit Oram, and he stated about the presence of Lalit on the duty on the date of occurrence. DW2 Kathu Kallo is a co-villager of the appellant who was deposed in favor of the accused persons about their absence. The Learned Additional Session Judge, without properly appreciating the evidence and other materials on record, has passed the impugned order of convictions and sentence accordingly. points urged on behalf of the appellants. The entire prosecution case is based on the evidence of the the so-called two eyewitnesses, PW8.
Now you don't have to read it line by line, sir. Now let's get down to PW8. You can read that part. Next page.
PW8 is the next page. PW8, my lord, this analysis is just on the next page, my lord.
Yes.
PW8, Debraj. My lord, I'm sorry, my lord, by the time I have submitted this note, some Odia versions.
No, it's all right. It's in translation, and Justice Patnaik is here. No problem.
My lord. In the FIR, my lord, in the FIR at page 57, PW8 mentioned as follows. 25th line of the FIR, my lord. While they were assaulting my father, my uncle Gopal Oram, and my elder father's brother, my lord, PW9 has seen. Out of these two witnesses, my lord, but the statement of PW8 is just contrary. In the court, in the chief examination, page 86, para 3, line 4, it mentioned the follows. Near a guy gotha, when we were coming, we saw both the accused persons coming towards us with tangi in their hands. Seeing this, I told my father to run away. Here, my lord, as per the evidence, the spot was changed. My uncle ran away from that place, and the tangi blow given by Lalit to me missed as I bowed down. I then ran away and concealed myself in a nearby bush. Thereafter, both the accused persons assaulted my father with tangi by giving multiple blows. It was a moonlit night. By that time, I saw the occurrence. After the assault, both the accused persons dragged my father by holding his hands and threw him in a ditch, and with the tangi, they went away towards the bandha. My uncle Lakshmana then arrived there, and we went to the place where my father was living. Lying. My lord, my humble submission so far this line is concerned, my lord, since PW8 and 9, both of them have a claim to be the eyewitnesses. PW9 is the brother of the deceased. PW8 is the son of the deceased. So far this line of PW8, my lord, indicates that PW8 had never seen, because I have underlined the line, my lord. My uncle Lakshman is PW9, my lord. PW9 claims to be an eyewitness, and the trial court has relied on the statement of PW9, and the conviction is also based on the statement of PW8 and 9. My humble submission before Lordship is, my lord, I have underlined this line, my lord, of the statement of PW8, because my uncle Lakshman Oram then arrived there, and we went to the place where my father was lying. So this clearly indicates, my lord, his uncle PW9 must have arrived at a time when the assault was over, and thereafter, my lord, where my father was lying. And by the time PW9 reached, my lord, the father was already assaulted and he was lying, and both of them went to see his father where he was lying. So my humble submission before Lordship is, my lord, that PW9, who claims to be an eyewitness, and the Learned Sessions Court, while relying on PW8 and 9, has found this appellants guilty, my lord. My respectful submissions, my lord, on a clear, the evidence of PW8 with the son. It is stated, if your lordship will go through his evidence, and on the analysis of the evidence, PW8 and PW9, your lordship will find that PW9 is never an eyewitness, and he is a post-occurrence witness. So he is claimed that he is an eyewitness, and the Sessions Court finding that both their eyewitnesses have seen the incident. PW9 should outrightly rejected by your lordship because of the statement of PW8, and which has not been demolished, which has not been challenged by the prosecution's while in the lower court. My uncle Lakshman Oram then arrived at the spot, and we went to the place where my father was lying. Well, I'm repeating. He was soaked with blood and struggling with life. He had sustained injuries on his head, forehead, and hand. We then went to the house of PW3 and brought some water. My father could not drink water. So, my lord, it is clear that PW9 reached at the spot while everything was over. Assault was over. So my humble submissions, if PW8 will be accepted, then the statement that PW9 is also an eyewitness can never be accepted, because as per their own showing, as per the statement of PW8, he PW9 is a post-occurrence witness who admitted he had reached the spot after the incident, after his father was already assaulted and he was lying dead, where they were trying to give him some water. From the aforesaid statement of PW8, it is clearly found that though the uncle Gopal Oram was present, but he was not examined. And then the above statement, your lordship found that not only PW9, but another Gopal Oram was also present. And if he was present, Gopal Oram was present, he has not been examined by the prosecution as a witness, although he is also an interested witness, although he is a relation, although he is a very important witness. And as for the statement of PW8, he was very much present at the spot, but he has not been examined by the prosecution. The reason is best known to the prosecution, my lord, to withheld from the witness box. PW9 Lakshman Oram arrived at the place after the assault was over. From the aforesaid statement of PW8, it is clearly stated that the uncle Gopal Oram was present, but he was not examined. And PW9 Lakshman Oram arrived at the spot after the assault was over. Therefore, under no stretch of imagination, PW9 can claim to be an eyewitness to the occurrence. Further, PW8 has stated that they went to the house of PW3 and brought some water for his father who could not drink. But PW3 has not supported his story, this story of PW8. So, my lord, this is not a small contradiction. Somebody says that while his father, the witness said that while my father was struggling for life and death, my lord, I went to the house of such and such persons and bring some water and gave it to my father. But he has not supported. So therefore, my lords, since these two appellants have been sentenced to life, my lord, your lordship will find how truthful these witnesses are. These may be small contradictions, my lord, but at least this indicates that this witness is not a 100% truthful witness because his father is deceased and the other witnesses are not supported, and his own evidence indicates that on the point where he stated that the role of the other witnesses, but they have not supported him. The next part. Therefore, on an analysis of affair and the statement of PW8 in the court, it is clear that though Gopal Oram, who was an eyewitness to the occurrence, has not been examined, and Lakshman Oram, who is a post-occurrence witness, has been examined. PW9, who had deposed as if he is an eyewitness to the occurrence. It is further stated that the informant PW8 in the affair that immediately after the occurrence, PW3 and PW5 arrived at the spot, but none of them have supported the statement of PW8. This is again interesting, my lord. As per the statement, as per the affair, my lord, PW3 and PW5 arrived at the spot immediately after the occurrence, but none of them have supported. Since PW8 has claimed that he concealed the backside of the Amari bush and found from there, he could see the assault by the appellant to his father. However, the spot map prepared by IO, page 142, exhibit 12, my lord. The spot map prepared by IO at exhibit page 142, exhibit 12, clearly indicates that the Amari bush situates at a distance of 150 feet from the spot. So, my lord, his claim is, my lord, the eyewitness has to be accepted if your lordship will accept that where he had, from what distance, and where he was there at the time of assault. Here, as per this prosecution case, my lord, as per the statement of PW8, that he had concealed himself behind a bush, locally known as Amari bush, my lord. The name of the tree is Amari, locally known as Amari bush. And a spot map has also been prepared, which has been marked at exhibit 12 in the lower court. And if your lordship, from that, my lord, your lordship held that it is clearly indicating that it's 150 feet, and it was a night time, and it was raining. So somebody is standing in the night 150 meters away from this place, behind a bush, in a night time.
150 feet. 150 feet, sir, not meters.
I'm sorry, my lord. 150 feet, my lord. Even if 150 feet, my lord, in the night time, it was raining.
What have you asked the IO on this, sir?
IO, my lord, once IO has prepared this spot map, my lord. IO has prepared this spot map, and if your lordship will now compare, this is my argument, my lord, this is my submission before lordship.
No. PW7 is a hostile witness. He is saying the Amari bush is 150 feet away. You want to rely on that to say that from that distance, PW8 could not have witnessed the occurrence, correct?
My lord,
What have you asked the IO about this?
IO, my
Amari
IO
Bush being 150 feet away.
IO never disputes the spot map, my lord. As per the spot map, I am
No,
submitting.
no. Have you asked him that this Amari Bush is 150 feet away?
My spot map, my lord, is IO, yes, my lord, by the IO at page 142. Left side, my lord, page 142. My paper is stored, my lord. But from the left hand side, my lord.
Yes, paper book.
He admitted that he has prepared the spot map, and he has not also, my lord, disputed that he has not prepared the spot map from the spot map, my lord.
The distance to spot on the omnibus would be.
And your lordship, I am obliged. My lordship asked me a very pertinent question. So your lordship may kindly see at page 111 of the paper book.
Yes.
Paragraph 23. During my spot visit, one Gopal Oram, Kirtan Nayak, and Boram Oram had accompanied with me. Gopal in one of the eyewitnesses this case, who had been examined by me. The witness Gopal Oram identified the spot. I have prepared the spot map where I have indicated the position of the witness during assault, and that has been prepared basing on the statement of Gopal Oram. The distance between the spot map and the Amari Bush would be about 150 meters. That is the admission.
Feet, 150 feet.
Yes, I'm sorry, 150 feet. That's the admission of the IO.
That's all right, sir. It's a moonlit night.
No. It in the night it was raining, my lord.
No, raining is only PW7 who's saying. Nobody else is saying that. PW7 who's turned hostile is saying that.
But even if my lord 150 feet from the distance from in the night time,
make it as distant as possible. All right.
And all right. I have also cited a decision, my lord. The hostile, my lord, the evidence of the witness, the evidence of the hostile witness cannot be thrown out as a whole, but the portions of the statement, either providing the prosecution case or proving the statement, either providing the prosecution case or proving the innocence of the deceased accused appellant, can be taken into consideration.
All right.
On the other hand, the evidence of the hostile witness cannot be rejected, cannot be rejected as a whole, but to the scrutinize of the same with caution.
Right, sir.
So, my lord, now the witness remains, my lord, PW8 and PW9. If your lordship will find PW8, PW9 has not to be accepted, because PW8's own admission indicates that is PW9 reached at a point of time when assault was already over, my lord. Then, my lord, your lordship. My lord, regarding raining, my lord, I have also mentioned in my note, my lord, paragraph Roman 4, my lord. It was raining on the night. Moreover, PW7 at page 84, para 3 has stated that on the date of occurrence, there was raining and rain continued for the entire night. In view of the statement of the witness that it was raining in the night and this.
So you're repeating yourself. We just now went through this whole thing, sir. You're only repeating yourself. You argued this 150 feet. You said it was 150 meters, kilometers. Then you came back to feet.
No. 150 feet.
We've gone through this enough, sir. We've seen the spot map. We've seen the IO's deposition. Now you have to go to the next point, sir. You have to go to the next point.
It can be kilometer, meters, it is feet.
Whatever. Only next thing is miles. You have to see if it's 150 miles. Right, sir. Now go to the next point, sir. Next point.
Place of occurrence. Place of occurrence, my lord.
Yes.
I have mentioned in my note, my lord.
Right.
Place of occurrence.
Yes.
This witness, PW8, as stated at page 88, last line, para 7. I have only told before the police DSP that near the Gaigotha the occurrence took place. However, the same witness, PW8, at page 89 in para 12, fifth line, stated follows. On the backside of the house of Boisakhu, my father was assaulted. Then, my lord, may kindly see. I have only I have told before the police DSP that near the Gaigotha means, my lord, the cows assembled. Gaigotha, the occurrence took place. And my lord, in the next line he says, however, the same witness, PW8 at page 89 in para 12 line stated, on the backside of the house of Boisakhu, my father was assaulted. But a very important witness, my lord, PW8, if your lordship will accept it, so he has to be convicted. And whether on the basis of the statement of this kind of witness, my lord, who changes the spot, my lord, before the police and one thing before the court, my lord, whether lordship will accept and send these two persons, my lord, for life, my lord, who were and they have been already convicted by the Sessions Court, my lord. So my next, my lord, on at page 88 of paragraph 9, this witness, PW8, has stated there are about 8 houses in Tolipara except Ramakrishna Oram and Moti Oram. Nobody else of that Para know about the death of the deceased in the night. It may be mentioned that Ramakrishna Oram, who has been examined as PW5, has not supported the prosecution case, and further he has stated, although he went to the spot to see the dead body, and at the time PW8, PW9, though were present in the spot, did not tell regarding the incidents. So other witnesses were examined from the Pada. So, my lord, my respective submission, my lord, the prosecution case is, my lord, the incident happened at in a local Pada, my lord, where number of houses are there, but none of them have supported this incident has happened in that night. And although the two witnesses are examined, they have also not supported.
All right.
Independent witness not examined, my lord, then, although PW8 on at page 89 at para 12 has stated the house of Samalal, Boisakhu were near the place of occurrence. However, both of them have not been examined by the prosecution. It is a specific case, my lord, near the house of Boisakhu and the other man, my lord, the incident had taken place, but both of them the IO has not examined. The law is well settled that non-examination of the independent witnesses and examination of only interested witness, my lord, that is the son witness is hazardous for conviction. Case law referred, my lord, I have already given the list. Then, my lord, PW8 at page 90, para 14, line 4 has stated, our clothes were stained with blood when we carried out my father from the spot. Police also saw the blood-stained clothes of ours during the investigation. However, PW12, the IO did not seize the wearing apparels of the eyewitnesses for chemical examination, my lord. This also casts a serious doubt regarding the veracity of the prosecution case, my lord, because it is stated that the clothes are stained with blood, but it are not seized. Law is well settled that in the absence of any blood stain on the clothes of the eyewitnesses who carried the injured persons creates a doubt about the presence of those persons at the time of incident. Then I have cited the case laws, my lord, I have given. Then coming to PW9, my lord. PW8 and PW9, since admittedly they are the two eyewitnesses, my lord. PW8, my lord, I have already given my comment. So far PW9 is concerned, my lord. PW8, if your lordship will accept PW8, that itself will demolish this presence, that itself will demolish the statement of PW9, that itself will create a doubt in your lordship's mind regarding the presence of PW9 at this spot, because he said that he came at a point of time while the matter was already over, while he was already assaulted. So he should be treated as a post-occurrence witness, my lord.
All right.
PW9, in his deposition at page 92, para 3, line 8, stated that I raised Halla and soon thereafter, Gopala not examined, and PW8 arrived at the spot. Again, PW9 at page 94, para 9 specified, though I saw the accused persons proceeding with the tangi, I did not call the villagers. The distance from the spot of my house will be 25 minutes. By the assault, the assault was over immediately. I did not raise Halla with the when the assault was started. I alone raised Halla after the accused persons left the place. Hearing my house, nobody came there except Upuri, PW8, and Gopal. From the above deposition of PW9, it is clearly indicated that PW9 is the sole eyewitness to the occurrence, and PW8, Gopal not examined, were the post-occurrence witness, as they both came after hearing the shout of PW9. On other hand, the evidence of PW8 indicates that after the assault, PW9 came. So, my lord, if your lordship will analyze PW8, as if PW9 is a post-occurrence witness, if your lordship will accept PW9, as if PW8 is a post-occurrence witness, he says after hearing my shout, PW8 come, PW8 says that after the incident was over, PW9 came. My lord, this is a case of murder, my lord. This is a case who had imprisonment for life, my lord. And this is the statement of the two witnesses on the basis of which they have been convicted. And except these two witnesses, my lord, there is no other witness, my lord, who claims to have seen. Rather, witnesses who claims to have seen have not been examined, and so one has been examined. His own brother has not supported the prosecution case, has been declared hostile. Then, my lord, regarding the place of occurrence, then, my lord, regarding this leading, yes, I have given some comment, my lord, regarding the place of occurrence. Place 9 at page 94, para 9 line.
Sir, you repeat. This is again a repetition, sir. You've already dealt with this in when you talked about PW8.
PW9, my lord, I'm placing PW9, my lord. Regarding place of
doesn't matter, sir. We'll go through this because this place of occurrence point you've argued earlier.
Yes, ma'am. Place of occurrence regarding in reference to PW8, my lord. Now, PW9, how he differs from the statement of PW8, I want to point out only 5 to 6 lines I mentioned, my lord. PW8, my lord. PW9, place of occurrence. PW9 on page 94, para 9, line 8 states that behind the house of Hotu, the accused persons assaulted him by tangi. However, from the statement of PW8, who has mentioned two different places of assault, one is backside of the house of Boisakhu, and the another at the Gaigotha. The assault was occurred. There, PW9 specified that behind the house of Kathu, the accused persons assaulted by tangi. From the deposition of PW8 and 9, it is clearly indicated that both the eyewitnesses' statement contradicted to each other, and more specifically, the statement of PW8 contradicts with the own versions related to the place of occurrence. It can safely be stated that inconsistency statement of both the alleged eyewitnesses were not the occurrence witness. It contradicts each other. I'm sorry, my line was disconnected for some time. It is well settled that the corroboration of the independent witness and the indispensable rule in the case where the prosecution primarily based on the evidence of seemingly interested witnesses. Then, my lord, regarding wearing apparel of the accused, my lord, PW9 at page 94 para 11 has stated, accused Hemanta was wearing a white full pant and a full shirt, the color of which I cannot say. I cannot say the color of the pant and shirts. However, the full pant which was seized and sent for chemical evaluation of the accused Hemanta, page 137, is a brown yellow color. Therefore, Lakhana, PW9, witnessing the accused at the place of assault, at the place of occurrence, cannot be believed. So, my lord, eyewitness, on the basis of which they have been convicted, he says by the time of the incident he was wearing a white pant. But the pant seized from him, if it is yellow, my lord. So his claim that he has seen a person assaulting, at least it appears that he is a liar, my lord, because the description has been given to him is contrary to the seizure, my lord. Seizure is the pant seized from the accused, my lord, is some other color, my lord. And the pant which he has described, my lord, the accused person was assaulting wearing a particular color of pant which was not seized, and the pant seized from the accused person, my lord, is a different color. So, my lord, this may be a very minor point, my lord, but it, my lord, casts serious doubt about the presence of the eyewitnesses that he had not seen the assault. Otherwise, my lord, while describing the dress of the accused persons, he would not have stated about a different color which the accused was not wearing. Then, my lord, Video 9 at page 92 para 3 mentioned that when I was 30 to 35 cubits away, I could see accused Lalit assaulting Saheb from front side of the Hemanta from the back side. However, period 9 at page 95 and para 13 states, I was examined by IO. It is not a fact that I have not stated before the IO. To my questions, the accused person said that they were going to kill Dui Guria, and that I had not said that I saw the occurrence from a distance. There is a contradiction, Smiler, which was asked to him, and he denied, and it is the same has been asked to IO, and the IO said that he has not stated before that, Milo. Then another item of evidence is also against these petitions, my lord, that is leading discovery of the weapon of offense, my lord. Leading discovery of the weapon of offense, I have also mentioned in my note, my lord. Okay.
Yes.
That is my lord, serial number 4. Leading discovery of the weapon of offense, section 27 of the Evidence Act, under section 27. PW 12, the IO, page 113, para 27, line stated, on 31/12/96, I arrested the accused Loritoram at 11:30 a.m. Accused Loritoram, while on police custody, disclosed before me and witness Shashi Bhushan Barik, PW 15, and Vikram Naik, PW 2, that he, along with accused Hemanta Patel, committed the murder of Sahib Oram by 2 Tangi. Again, PW 12 IO at page 114, para 28 stated that I arrested the accused Loritoram on 31/12/11:30, 31/12/11:30 at the police stations, but my case diary does not show as to where I arrested the accused. I recorded the disclosure statement of the accused Loritoram at the police stations before his arrest, but I have not mentioned such facts in my case diary. So, my lord, this casts a very serious doubt about the genuineness of the statement recorded by the IO under section 27, the Evidence Act, my lord, that is leading discovery. From the above 2 statements of the IO, PW 12, relating to disclosure statement of accused Lalit, whether before his arrest or after the arrest is doubtful. Both the seizure witness of the weapon of offense, PW 2, PW 15 statement do not corroborate with statements of the IO. PW 2, Vikram Mehra, at page 72 para 3 stated, the 2 days thereafter, again, IO came to our village along with the accused Loik.
So we'll go through your note, sir. We will go through your note because you're anyway reading it only line by line. We'll do the same thing, sir.
So,
we'll go through your note. We'll go through your note, and there is a detailed note of the prosecution also. We have seen that also. All right. We'll go through both the notes, sir. Very detailed notes have been prepared. You can be assured we'll deal with every point you have raised. All right.
That assurance creates confidence in my lord. And
correct, sir. Correct. Orders reserved. We'll continue after lunch, sir.
My lord, may to the co-villagers that are known to them during the part of the night, that part of the night, light of the moon, as claimed by them, cannot stand a scientific test. We should quote the extract from Grant's Hans, my lord. There manifested the maximum is, my lord. The maximum is, my lord. By moonlit night, one can recognize when the moon is at a quarter, presence at a person's distance at from a 21 feet. In the bright moonlit night from a 23 feet, and in the 33 feet, and at the every brightest period of the full moon at a distance from 33 to 36. Highest is the 36, my lord. Your lordship has seen 150, my lord, 150. But highest is the 36, my lord. Another authority also, Dr. Vincent, that he has said, I will give it, my lord, I have already given my note and decisions. Your lordship will kindly accept this decision on our side. And here it is stated that the maximum is 36, maybe 50, my lord, but here is admittedly 150 as per the statement of the eye. So once, my lord, the eyewitness who had seen them 150 feet away, it is not possible, my lord, today.
All right.
I am obliged.
My lord, and senior was distinguishing the evidence of people 8 and 9 who are the eyewitnesses. Only plus, I would like to draw your lordship's attention to page 86.
Yes.
Well, there are 2 phases. That incident happened in 2 phases.
Correct.
So, let's 86. I am coming.
First, they have hit him with fists and all that. Go back, come back at 8:30.
Yes. Correct. Right. And also regarding the evidence of defense witnesses, and you'll also find from PW 8 and 9, no suggestion, not a single suggestion has been put to these witnesses regarding plea of alibi or any other plea loss. Because in the 313 statement, one has stated, Hemant Patel, she has stated this case has been foisted against me. And the other, Lalitoram, he has stated, I was on duty on 29/12/1996. Even this is not
he is a policeman.
Acceptable because no suggestion has been put to that.
He's supposed to be a policeman.
Yes,
policeman, and he said, I was on duty. That is the plea of alibi.
Correct.
And that is the reason why I am saying
defense witness.
Right.
So no suggestion has been put to any of the witnesses.
All right.
Regarding he was present on duty, and so the defense is concerned, defense witnesses plus DW1. That is plus. I am reading.
Arun Kumar Sethi.
At 127. Yes, it starts from 126. Again, plus I am last 4 lines I am reading. Again, Lalitoram was on duty on 29/12/1996 from 6 p.m. to 8 p.m. and I relieved him at 8 p.m. on that day. After 8 p.m. on 29th December 1996, accused Lalit Oram left the SP residence for the barrack in Jharsuguda police station. Plus next page 127, cross-examination. There is no duty, plus 3 lines.
Correct.
There is no duty register in respect of DIB guards. We simply issued a command certificate. It is not a fact that on 29th December 1996, accused Lalit Oram didn't report to his duty. So this itself will falsify the evidence of DW2. And DW1. Then DW2, you'll ask me, come to page 129. He has stated at paragraph 2, police had not examined me in this case. Also, I didn't voluntarily appear before the police, nor made any statement.
Right.
He could have said it before the police during the course of investigation. So I have, in detail, I have given a written note of submission.
Correct, that we saw.
One line reply to Mr. Katiya's statement, my lord. Taking a false plea, my lord, the prosecution has to prove its case beyond all reasonable doubt when the defense requests to prove the case, my lord, the principles of preponderance of probabilities. My lord, prosecution cannot take the any weakness of the defense. Prosecution has to prove the case beyond reasonable doubt, my lord. And the defense, my lord, the defense, his one friend who has been examined at DW, he said that I was on duty and I was replaced by him. Thereafter, he replaced me, and he was very much present at the time of incident of the duty. That is, his one friend said, and nothing has been brought out.
He said no, Nati means grandson.
Correct.
He just said Nati, grandson. Only because he was SC, scheduled caste people. That is the reason why these are general caste people. He tossed him. That is the reason why those persons have reacted.
Correct.
Okay. This is the argument from first time you are advancing, but nothing is there in the record.
Old man will say grandson. What will make them to get so angry?
So angry that they'll come back and kill.
Yes.
Correct. All right. Orders reserved. Yes, Mr. Das.
In this case,
yes,
three petitioners were arraigned in a case under section 302 IPC.
Right.
The prosecution case in brief is
all are on bail now, sir.
All 2 are on bail. Number 3 has already undergone the sentence and has been released from the jail.
All right.
And if your lordship will kindly, so far the motive part is concerned, if your lordship will kindly see the evidence of one PW7. PW7 at page 94 of the paper.
Jagannath Hemram.
Yes. I know all the accused persons. I also know Dasarathi Soren. Dasarathi Soren is dead. Luski is the sister of Nota Hembram, who had married Dasarathi Soren. Nota is one of the accused who has undergone sentence and has been released.
Right.
The marriage was not regular negotiation. Luski was separated from Dasarathi Soren by the time of occurrence. The relationship between Nota Hembram and Dasarathi was bitter at that time. The occurrence took place about 2 years back in Kali Puja festival. On that occurrence of night, PW4 Bajal Soren, the brother of Dasarathi Soren, told me at my house that Dasarathi Soren had been killed in the house of Nota Hembram. After taking food during the morning hour, then your lordship listed, then cross-examination, Luski and Dasarathi Soren were separated, for which they had approached the police station. So far, Dasarathi, there were some differences. But so far, the other 2 accused persons, the prosecution has tried to implicate them as if all the 3 accused persons were present. They have lifted this deceased Dasarathi and assaulted inside the house of Nota. Thereafter, they threw him outside. I have given a detailed note, but if I kindly try to do your lordship, they are all brothers. PW4 is one of the brothers. If your lordship, PW4 is one of the brothers who had said, PW4 at page 86.
Najal Soren.
Yes. I returned back home at about 6:30 to 7 p.m. When I was returning back home, I saw my brother Dasarathi Soren was lying in the front side of the house of Nota Hembram, and there was bleeding in his house. Thereafter, they removed the dead body and all that.
Mm.
Then your lordship may see cross-examination. On the day, first of all, I returned back home and from the Hatto, and thereafter I went near the house of Nottahembram. Myself, Musu Soren, PW10, Kalyan Soren, he has not been examined, who are my brothers, and Fogu Soren, PW, went near the house of Nottahembram. By that time, my brother Dasarathi was lying alone at the front side house of the Nottahembram. There was darkness. We examined Dasarathi using torchlight. Thereafter, we brought Dasarathi by means of potter and etc. etc. Then your lordship may kindly see PW5, another brother. Their case is all the brothers went together. They heard the sound. Dasarathi was calling them by their name and was saying they are killing me, they are killing me. Then your lordship may see another brother, page 91. He is PW5. His statement.
Yes.
We, the brothers, had gone to the house of Nottahembram at paragraph 6. Yes. We, the brothers, had gone to the house of Nottahembram at a time by which time Dasarathi was on the ground near the veranda of Nottahembram.
Right.
So, this.
What is the story of the defense, sir?
Defense has no story, Millers. Defense has no story.
Oh. Right.
Defense has
But
no
the fact
story.
is the body is found in Nottahembram's house.
Yes.
Ah.
No. There was a conflict between Dasarathi and Notta.
Right.
Then all the other two persons have been used, and their own statement shows they have stated before the police that we heard that our brother was saying, calling our name, but he has himself said that I have not disclosed this fact before the IO. He himself has said in his statement.
Okay.
And the occurrence took place long back in the year 97.
Right. All right.
And we
All right.
I have
Right,
given
sir.
a note compiling this
Correct.
statement.
We'll examine it, sir. We'll examine.
Obliged.
Yes, Mr. Katkia.
Plus. PW3, PW5 and PW10. These are the eyewitnesses. Here was a principle of res geste will be in operation so far as this case is concerned. Plus, I am reading the evidence of PW3.
All right, I will see it.
Plus, I am giving 3 citations for lordship's kind perusal. Plus, I am reading from the beginning. I know all accused persons.
Yes.
Dasarathi Soren, since date is my younger brother. I am residing in village Dimia in the house of my father-in-law. My parents, my other brothers are residing in my native village. Gandhi Diho under PS Suryapada. The occurrence took place about 2 years back during Kali Puja festive occasion. I was present in my father's house at village Gondia Diho. On that day evening at about 6 p.m. when I was present in my house at Gondia Diho, Masu PW10 came running to my house and told that when he was going to witness Bandhana Jatra, the festival of that local festival, at a field, he saw Nottahembram, Dula Hembram and Kandra Hembram were assaulting Dasarathi Soren in the house of Nottahembram. He also told that Nottahembram was armed with axe and Dula Hembram and Kandra Hembram each were armed with lathis. Myself, Kalyan, Rajendra went to the house of Nottahembram. At the house of Nottahembram, we heard dhad sound, striking sound. Dhad sound is striking sound from inside the house, room. And Dasarathi Soren was shouting to save him as Nottahembram, Dula Hembram and Kandrum Hembram are assaulting him from inside the house of Nottahembram. Though Kalyan pressed the house door of Nottahembram, but the house door could not be opened. Then we are standing outside the house of Nottahembram for few period of time. The house door of Nottahembram was opened and all the accused persons threw Dasarathi Soren outside the house and ran away. We found caught bleeding injuries on the right side forehead above the eyebrow and also bleeding injuries on the back side of the head of Dasarathi Soren. Dasarath Soren was suffering pain which we found from the movement of his body. Immediately we removed Dasarath Soren to my house and told him on a cot, and I went to hire a trekker. In the trekker, we took Dasarath Soren to Costa Hospital and reached there at 8:30 p.m. I showed Dasarath Soren to the doctor, but the doctor opined that he is dead. Plus, for a moment, I am drawing Lordship's attention to PW10.
There's nothing in the cross.
Page 99.
No, there's nothing in the cross.
Yes, no, nothing. And plus, what the deceased was saying, he was shouting to save him, taking the name of all the three accused persons. And that has been clearly stated by PW10.
Muso.
Yeah. 3 witnesses have stated.
Sorry. One second. 100. PW5 had gone along with them. I have read the PW5 statement. We brothers have gone to the...
Right.
Minor aberrations will be there in every prosecution, in every case. Those are the judgments. Minor aberrations will be there. And these are the people, tribal people. They cannot be equated to the people who have seen the advanced way of life. Their approach, their way of talking the court, their understanding is different. I can also provide the judgments. Plus, I am saying what exactly they have stated. Page 100 plus. I am calling it PW10.
Yes.
Middle, about the house door. I have also got it plus. But the house door of Nota Hembrom was closed from inside. Then next part is important. Dasarath Soren was shouting while calling our names that Nota, Dula and Kandra were assaulting him. My brother Kalyan, though attempted to open the house door of accused Nota, yet he became unsuccessful. So Dasarath, the deceased, was saying that Nota, Dula and Kandra were assaulting him. This is racist. This particular statement of the deceased, even if she is no more, this is an exception to the usual rule that hearsay evidence is not admissible. Section 60 says evidence should be direct, oral evidence must be direct. But there is an exception is Section 6 of the Evidence Act. For a moment, I am drawing Lordship's attention to Section 6.
Let's just take.
Okay. Relevance of facts forming part of same transaction. Facts which, though not in issue, are so connected with a fact in issue as to form part of the same transaction, are relevant, whether they occurred at the same time and place or at different times and places. Plus illustration 1. A is accused of the murder of B by beating him. Whatever was said or done by A or B or the bystanders at the beating or so shortly before or after it as to form part of the same transaction is irrelevant.
So this illustration A is relevant here.
Yes, this is racist laws. This is exception to the usual rule of hearsay evidence. So I have cited 3 judgments. I am taking Lordship to first judgment, Ratan Singh. There also kind of, I'm coming to page 15. Para 15, page 166. First judgment. Plus, there the fact is sort of like this. When Kanta Devi, the deceased, made the statement that appellant was standing with a gun, she might or might not have been under the expectation of death. But that doesn't matter. The fact spoken by the deceased has subsequently turned out to be a circumstance which intimately related to the transaction which resulted in her death. The collocation of the word in section 32(1), circumstances of the transaction which resulted in his death, is apparently of wider amplitude than saying circumstances which caused his death. There need not necessarily be a direct nexus between circumstances and death. It is enough if the words spoken by the deceased have reference to any circumstances which has connection with any of the transactions which ended up in the death of the deceased. Such statement would also fall within the purview of section 32(1) of the Evidence Act. In other words, it is not necessary that such circumstances should be proximate, for even distant circumstances can also become admissible under the subsection, provided it has nexus with the transaction which resulted in the death. Then Sarda case, then para 16 I'm coming next. Even apart from section 32(1) of the Evidence Act, The aforesaid statement of Kanta Devi can be admitted under Section 6 of the Evidence Act on account of its proximity of time to the act of murder. Illustration A to Section 6 makes it clear. It reads thus. That is the illustration. Here, the act of the assailant intruding into the courtyard during dead of the night, victim's identification of the assailant, her pronouncement that appellant was standing with a gun and is firing the gun at her, are all circumstances so intervened that each other by proximity of time and space that the statement of the deceased became part of the same transaction. Hence, it is admissible under Section 6 of the Evidence Act. In either case, para 17 was. Whether it is admissible under Section 32(1) or under Section 6 of the Evidence Act, it is substantive evidence which can be acted upon with or without corroboration in finding guilt of the accused. Plus, next judgment, that is Sukhar versus State. There also Honorable Apex Court has referred this judgment, Ratan Singh judgment.
Right. Then you don't need to repeat it, sir.
Well,
all right.
Then I have given another judgment because Nand Kumar, because one plea that is regarding number of witnesses, what is to be examined, that PP has to decide who is to be examined and who is not to be examined. Right. The discretion of the PP.
Right.
Because my learned seniors has made a statement that Kalyan has not been examined.
Right.
If the people will feel that Kalyan will be hostile towards prosecution,
I'm not.
PP may decline.
I was only submitting on facts. A law can be flow from the facts, my lord.
Right.
My lords,
only judgment, another judgment I can provide your lordship regarding minor aberrations anywhere.
That is a very standard.
Minor.
My lords, one line, my lords, at page 102 of the paper book. Your lordship, para 6, PW 10. I was examined by the police in this case. I had not stated before the IO that Dasarathi was shouting while calling our names that Nota, Dula, Kandra were assaulting him. But I have stated before him, Dasarathi was shouting while addressing we brothers. Nota Bhola were assaulting him, requesting to rescue me. Thus, your lordship just see the statement.
Well, I think they tried to confuse him.
all our brothers. Two brothers say all our brothers went together. Two say when they went there, they found Dasarathi was lying. He is dead. I don't dispute. He has been assaulted. I don't dispute. But the question is, how can there be a contradiction between 5 brothers when they are saying one thing and 2 brothers are saying another thing?
Or there is no contradiction. Is a critical interpretation by Lord Senior of the statement given by the witness.
Interpretation. I am only stating facts, my lord. I am not interpreting.
Right. All right. Order is reserved.
Obliged.
Right.
Number 25.
You told Soumya.
ମିଲଣ ମୁଁ ଓକିଲ ଚେଞ୍ଜ କରିବା ପାଇଁ ଚାହୁଁନି।
He is stating that he wants to engage his own lawyer.
Whatever, sir. You said today the appellant has appeared in person and states he wants to engage his own lawyer, although this court has provided him a lawyer from the High Court Legal Services Committee. Paragraph, it is unfortunate that although the OHCLSC has assigned the matter to Mr. Saubhagya Ranjan Jaina and his name is also shown in the list, he has chosen not to appear despite a passover. Full stop, he is also not picking up his mobile phone. Full stop, this is most unfortunate. The Secretary OHCLSC will call for an explanation from Mr. Jaina for this conduct. Full stop. List on July 28th. The appellant will remain present on the next date as well.
Next date July 28th.
If he has not made his own arrangement by then, the OHCLSC will ensure that some other panel counsel is present to appear on his behalf.
Plus, he will engage.
He has to engage, but on the next date, if he is unable to engage, we are going to ask the secretary to send another counsel so that the case goes on.
Yes.
Whether he has engaged or not.
Yes.
You please explain.
ଆପଣ ଓକିଲ ଆପଣ ଏନଗେଜ କରିବେ ସେଦିନ ରହିବେ ଯଦି ନ କରିବେ ତାହେଲେ 26
ये हम नया वकील देवा नहीं चाहूँगी सुशांत कुमार प्रधान को देवा नहीं चाहूँगी सर.
Who was that? There was a lawyer, no? Ah. Carry on, carry on. Tell him we have engaged her for him. She will argue the case.
The appellant says, he will engage one Mr. Sushant Kumar Pradhan.
Where is Mr. Pradhan?
Lordship. Allowed to file Bhinama, Lordship.
Sorry?
Allowed to file Bhinama, Lordship.
We are allowed to file the Bhaklat number. His Bhaklat number on there.
All right. Where is your paper book?
Lordship.
Miss Das. You are Miss Das.
Yes.
Where is your paper book?
Sorry to tell.
Sorry?
I'm not bringing the book.
I'm not able to hear you. Please speak into the mic.
Paper book is not with me.
Why?
In law.
Sorry?
Sorry to tell.
No, I don't understand. What is he saying? I'm not able to hear. Why?
Paper book is with you or
yes, with her. She has forgotten to bring the book.
This is a high court. This is a criminal appeal listed for hearing. How can you forget? Where is your chamber?
Near CD. CD Kotak.
Do you have the paper book, sir?
No, sir.
So you are helping him get an adjournment. You are helping him get an adjournment.
Okay.
This is your task as a legal aid counsel. You are supposed to do this. You are supposed to help people get adjournments.
No. I will help him.
You have to ask Soumya to again get an explanation. What is this kind of a... You see, the panel counsel, Ms. Sarita Das, who appears today, states that she has single quotes forgotten, unquote, to bring the paper book. Full stop. The court finds this explanation to be strange. Again, the court is constrained to require the Secretary Orissa High Court Legal Services Committee. I'm sorry, you're cutting a very sorry figure before a high court.
Pardon, Lordship, I will.
You're doing a great disservice. You're doing a great disservice to the High Court and to your profession. I'm sorry to say this.
Pardon, Lordship.
your name appears in the cause list and you should have come prepared with the paper book.
I am not prepared for
And you say that you have forgotten to bring the paper book. This is unfortunate.
Unfortunately, I will not prepare.
The Secretary High Court Legal Services Committee will seek a proper explanation from Ms. Das for this conduct. One, Mr. Pradhan today files an wakalatnama on behalf of the appellant and states that he will be appearing in this case. List on 4th August. It is made clear to Mr. Pradhan. We are making it very clear to you. Just come to the mic, sir.
Lordship.
We are making it very clear to you. We are not adjourning this case on 4th August.
Lordship.
Either you have to pick up the paper book today or you do whatever.
Lordship.
We are not going to adjourn. That day, don't come and say, I have no paper book, I have no instruction.
Lordship.
All right, you have to argue the case on 4th.
Lordship.
Yes.
Lordship, Mrs. Das, Miss Das, maybe given me that paper book, Lordship.
Sir, we are making it clear to you, Miss Das may vanish today. All right.
Lordship.
She may not bring the paper book. That is not our headache.
Lordship.
You have to make sure you get the paper book, you get ready with the matter. We are making it clear to you, sir, again and again.
Lordship.
4th August, this case will go on.
Lordship.
Have you understood?
Lordship.
Kindly collect the paper book today itself and be prepared on the next date.
Lordship.
Yes.
The appellant will continue to remain present on the next date. You ask your client also to remain present on the next date.
Lordship.
Yes.
Item 28.
What is that? 26 minus.
Yes, sir. Carry on.
PW1, my lord. PW1 and PW4 is the eyewitness.
Right.
And my lord, and the page 25 in the cross-examination, the PW1 stated from the beginning, my lord, I'm reading. I have not stated before the IO that the accused was wearing a ganji and a lungi, that the deceased was wearing a striped shirt and half pant, and I was not asked by the IO regarding the koturi and the lathi like the material object, and are available in our village. And there was no police case for the earlier prior to the dispute between the accused and the deceased. It is not a fact that there was such a previous dispute between the accused and the deceased. The dispute had taken place 5 years prior to the occurrence, but thereafter they were pulling on well by the time of the occurrence, and there was a good relationship between them. And my lord, at page 28, para number 4, the PW2 has stated that the katis, the metal objects likes are not commonly available in our village. Manas is using this kati for the purpose of cutting the trees. My signature does not appear on this paper, listed on the. And my lord, he has also stated the accused has revealed before me at the time of that he had inflicted the court blow, that is the Hani Deichi to Rasa Pradhan. It is a extrajudicial confession, my lord. And the PW4 is also the eyewitness. He is the wife of PW1. And all are related to each other, my lord. The accused and the deceased. And he has stated that Manas Pradhan being sitting in the dock, he is my Devar, being the son of my Kakasura. Similarly, the deceased Rasa Pradhan was also my Devar, being the son of the another. So, I pray for one day only to.
For what? No, we are not adjourning, sir. Don't go on asking like this.
Only one.
We are not adjourning. Sorry.
Only one day.
No, sir. Please don't repeat it. We are not adjourning it. Yes.
The accused is already released by the board after 14 years of the conviction.
All right. Anything else you want to say, sir?
No.
He has already been released.
Yes. By the board.
Is that right? Mr. Katke, he has been released.
No, so
Where did you get this fact?
I have asked the. No, on 5/5/2022, I have received a report from the DSP Swadhar Tinkanar. He has stated that it is ascertained that he was released since last 10 months on bail, and now he is maintaining his livelihood by labor work at a catering service.
He was released on bail, sir.
Yeah.
He told me that
He doesn't understand, obviously. He's on bail. Yes, Mr. Katke.
Because there, PW1 and PW3 are the eyewitnesses in this case.
Right.
And PW8 it is the PM, doctor who has conducted autopsy.
No, 4 is also an eyewitness. Kunjara Pradhan.
Yes, plus. Pardon. 4, PW4. It's quite straight, because they have stated all the eyewitnesses. In PW1 stated that the accused Manas came there holding a kati and a tangia.
Yeah. Husband and wife. 1 and 4 are husband and wife.
Yes, in-house murder.
Correct.
Cousin has killed another cousin.
Correct. That's why they never suspected it will suddenly do this.
Yes, plus. They are also related to the deceased as well as the accused. Witnesses.
There is no cross-examination, nothing.
Nothing. Nothing substantial has come out in the cross. Ape is the wearing apparel lungi of the accused, which was stained with blood. That is page 60 plus the chemical examiner report. That has also not been answered in the statement recorded in 313 CRPC.
Yes. What is the doctor's evidence? He's PW?
8. It starts at page 42. I found only one incised wound of size 3 inch into 1.5 inch, wide and 1 inch deep, transversely present over the neck, more towards the right side. It had cut down trachea, separating it from the larynx below the thyroid cartilage. It had also cut down the skin, plasma, and struck muscles of the neck.
All right.
A heavy blow has been given.
Right.
Single blow, but heavy blow has been given.
And he is unarmed, totally unarmed. And no provocation.
No provocation.
All right. Anything you want to say, sir?
PW1 has also stated in page number 2 that is the occurrences took place all of them sudden.
Correct. But without any provocation, sir.
But there
He
is,
has come there. The accused has come there.
but W W3 is stated in cross that by the time the accused came to our house, it was already dark and it is very difficult to identify a person.
All relations.
It was
Then
raining
they can
heavily.
even-
It is rained throughout the night and I did not come out of my house that night. That night, nobody came to me.
With
As
slightest sound, they can know each other because they are relations. Even in villagers can recognize each other. Even
Yeah,
at
yeah.
night. Hours.
It was a very dark night. It is not possible to identify the person who came.
All right. You submit a note, sir. Within 4 days, you say orders reserved. It will be open to the parties to submit their respective notes of arguments within 4 days.
Along with judgment.
All right.
Item serial number supplementary list item 10, madam.
Can't hear you, sir.
Madam, supplementary list item 10, madam.
Item?
Item 10.
Ah. 10?
Madam, kindly be taken up today, madam. Supplementary 10.
Sir, supplementary list is item 10 and all is over, sir. What is the case number?
Case number, my lord, jail criminal appeal number 118
Sir,
of 2004.
that is weekly list, sir. That's not supplementary list. It's weekly list. You kindly wait. Kindly wait.
Item number 30.
Yes, madam. Come.
Lordship, in this case, it's no direct witness
Yes.
and only suspect, Lordship. And Lordship, kindly see the judgment para 2, Lordship.
Yes.
May I read, Lordship?
Yes, please.
The prosecution case in short is that on 17/5/2009 at 10 a.m. Koinala.
My humbly famous. Maybe kept on board. Next matter I am reading.
Let us start, sir. Let's see. Yes. Otherwise, she will not be ready. She'll keep on taking adjournments. Nothing will happen.
Karkaria, son of the accused, took the deceased boy, Biju Kaushalya, aged about 3 years, and Sahadev Mahanandia, aged about 5 years, while they were playing. It was seen by PW11 Rajini Kaushalya, daughter of informant Bhima Kaushalya. Deceased Biju Kaushalya is the son of informant Bhima, and other deceased boy Sahadev is son of Kartik Mahanandia, PW2. At about 12 noon, accused Banda with his sons and wife left the case village on the pretext that his mother was ill. Accused Banda originally belonged to village Rebel Khan, but he came to case village Tading Pai. 2 years prior to the incident, the villagers of case village did not pay any importance of such living of the village by the accused with his family. However, till 2 p.m., as the deceased boys did not return home, the villagers searched for them, but they could not trace out. During course of search, on the following morning at 6 a.m., the villagers found that the deceased boys were lying dead with injuries on their necks at Lamba Kupuli land. Accused Banda Karkaria was not pulling on well with informant Bhima and was quarreling with them, and he has threatened to do away with the life of his children. Hence, they apprehended doubt about involvement of the accused as well as his son in committing murder of the deceased boys. Biju and Sahadev. PW1 presented a written report by Executive 4 in the above stated lines at Bisam Katak police station on 18/5/2009. The police treated the written report Executive 4 as FIR and registered the case against the accused as well as his son Koinala Karkaria alias Santosh. The police during course of investigation held inquest on the dead body of the deceased boys by Executive 1 and 2. The inquest reports seized one knife, one torn towel, blood-stained earth, and sample earth from the spot. By Executive 3, the seizure list sent the dead bodies to Bisam Katak Hospital for postmortem examination. Under dead body challenge, Executive 12 and 13 obtained PM report, seized the scalp hair of the deceased and other malice put on by the deceased boys. By Executive 10, the seizure list arrested the accused as well as his son at Chintanguda on 19/5/2009. Seized the wearing apparels of the accused Banda Karkaria, that is dhoti and shirt. By Executive 1, the seizure list, and on leading to discovery by accused Banda Karkaria, the police recovered and seized one katuri, one photo of the deity, one shirt and jean pant from the house of the accused. By Executive 9, this seizure list recorded the statement of the accused. By Executive 8, collected nail clippings of the accused, sent the seized articles for chemical examination. By Executive 16, and after completion of the investigation, submitted charge sheet against the accused as well as his son. But the son of the accused being minor and juvenile, his case was sent off to the designated court, and hence this case against the above accused only. Sir, that's it. And Lordship, kindly see the para 7, Lordship. Judgment.
Yes.
Lordship, kindly see the para 7. As seen from the prosecution case, there is no direct evidence to connect the accused with the offense. The prosecution case rests on the circumstantial evidence. In this connection, it is submitted by the Law and Defense Counsel that the prosecution has to fully and satisfactorily prove the circumstance from which the conclusion of guilty of the accused is to be drawn, and the circumstances so established should be consistent with hypothesis of the
That's all right. This is all. Let's come to para 8. Para 8.
Para 8, Lordship. The following are the circumstances as per the prosecution case. Last in theory, Lordship, time matter is very gap. Last in theory. Lordship, and kindly, as per the prosecution, Lordship, kindly see the PW 11, that is the last in theory, she is established, Lordship. PW 11.
Yes.
I know that accused, so also his son, namely Kuila, the deceased was my brother. The deceased, namely Biju, was my brother, and the other deceased Sahadev was son of Kartika. The incident took place about 1 year and 2 months back. It was Sunday. At about 10 a.m., the deceased were playing in the village Padia, at the outskirts of the village. I found accused Kuila, son of this accused, took the deceased boys with him by holding their hands towards the mango top. I questioned as to where he was taking the boys, to which he replied that he was taking them to give mangoes. After that, he will leave them. Then I went towards my house. Then I found accused by putting on Gerua dress was going towards Lumbakupuli. He was holding something in his hands. I narrated about the said incidents to my mother, who in turn informed to my father. My house intervened 2 houses from the house of the accused. I saw the accused with his son came in hurried manner, vacated the house, and left for his village, saying the mother of the accused was ill. The entire villagers searched for the missing boys, but they could not trace. On the following morning, during course of search, we found the dead bodies of both boys lying under a mahulla tree in Lumbakupuli land. Both had caught injuries and bleeding from their throat. The accused was doing Devi Sadhana and he was killing of the hens of the villagers and throwing out due to the region. The accused had issued threatening to kill my brother due to region we suspected had murdered both the boys. And cross-examination, Lordship. I had examined by the police at my village. I had gone to police station 3 to 4 times. I had met the IAC after this case. I have seen the incident which I deposed, and the police also told me to depose in this way. Police Babu gave me in writing which I have deposed in the court. Lordship, she admits that she has been tutored by the police Babu. This time, let's kindly see another. Once Sushil had read over to me, she might have read over 3 to 4 times to me. I have kept in memory and deposited today in the court. The boys were playing at the entrance of the village. About 8 to 10 children, including
But she again
these
denies
deceased boys.
it's not a
were
fact that I'm
playing.
deposing falsehood towards the end.
Lordship?
The last 2 sentences. It is not a fact.
It is not a fact.
Last 2 sentences.
It is not a fact. I am deposing falsehood against the accused because being tutored by the police. Lordship, the last theory I am saying, Lordship, as per the prosecution, PW11 is regarded as the witness to last theory, but she is not reliable, Lordship. As per her statement, at about 10 a.m., the son of the accused took the 2 deceased boys with him towards the mango top. Thereafter, she saw the accused with his son come in hurried manner, vacated the house, and left for his village, saying the mother of accused was ill. At that time, she never inquired about those 2 deceased boys.
Anyway, all right. All right. Come to the next circumstance. Para 8 of the trial court judgment.
Para
8 of the judgment of the court bill.
Lordship, para 8. The following are the circumstances as per the prosecution case last in theory. Enmity, the accused left the village with his family, leading to discovery of the weapon of offense. The accused was doing certain pujas and hence he murdered the boys as offering bali and blood stains found on the wearing shirt of the accused.
Yes. What do you have to say for the rest?
With regard to presence of enmity, then the accused was
Blood
found
stains.
leaving the village with his family immediately after the occurrence. Other circumstances, as per the court below, it has been proved, or each and every circumstance has been proved.
No,
And therefore,
Lordship, enmity is there. She is slaughtering the of their hen.
Come to para 11. Para 11.
The next circumstance is the recovery of the weapon of offense and the photo from the house of the accused at his instance. In this case, PW12 has stated that the accused in police custody admitted to have kept the kati and other articles in a bag in his house. The police recorded the shared statement, which is marked as Exhibit 8. The accused was taken to village studying by. He brought out a bag from the house and the bag contained 1 photo of Detri Maji Gauri, 1 kati and a dress of son of the accused stained with blood, and the police seized the same by Exhibit 9, the seizure list. In cross-examination, he stated that he went to the police station on calling of the police One, Krishna was also called to the police station. He signed in the papers at the police station. Similarly, PW14, the IO has stated about recovery and seizure of the said articles at the instance of the accused. In this connection, it is contended by the learned counsel for the accused that the police has tutored this witness Chakra Munda to depose against the accused. He is not competent witness as much as he does not belong to village starting by the place of incident. He is a man from different village. That apart the next contention raised by the learned counsel for the accused is that the seized articles are marked as MO3, MO4 and 5 and 6. The said articles have been sent for chemical examination, but no blood stain has been noticed on the said articles. Thus, the recovery of the articles is of no help to the prosecution. It is true that no blood stain was noticed on the seized Katuri MO3, which is marked as L in the chemical examination report executive 17. Yet the medical officer PW10 has stated that the injuries found on the person of the deceased boys are possible by instrument like MO3. It is also the case of the prosecution that the accused was performing some puja and slaughtering hens of the villagers. The fact that a photo of the deity has been seized from the house lends corroboration to the statement of the witness that the accused was doing puja.
Come to para 12 now.
The next circumstances is with regard to the presence of blood stains on the T-shirt of the accused. PW14, the IO has stated that he seized the wearing apparels of the accused, that is his dhoti and banyan. Executive 14 is the seizure list. As per Executive 14, the seized banyan was red in color and marked as Executive J. PW14 has stated that he sent the seized articles for chemical examination. As per Executive 17, the chemical examination report, the T-shirt marked as Executive J contained human blood of group B. As per Executive 3, some blood stained earth was seized and it is marked as Executive C for the purpose of identification. As per chemical examination report, human blood was found on the earth and it is of group B. The group B blood is that of one of the deceased. The same blood is found on the shirt worn by the accused. Thus, it is proved by the prosecution that the blood stain found on the shirt of the accused was that of one of the deceased. As per seizure list, Executive 14, the banyan was red and the dhoti was gerua in color. It is the evidence of the witness that the accused was performing puja sadhana and was using gerua vastra. Thus, on analyzing the evidence of all the above witnesses, it is clearly proved by the prosecution that the deceased boys were last seen in the company of the son of the accused. Soon after that, the accused was seen going hurriedly towards the place of incidents. On the same day, the accused with his family members fled away from the village and the accused was enmically disposed of with PW1 and 2. The accused was also doing some puja and he had threatened PW1 and 2 with dire consequence. It is also coming from the evidence. Besides the deceased, some more children were playing and the son of the accused picked only the deceased of the deceased as the children of the PW1 and 2 were enmically with the accused. Thus, the accused and his son, in furtherance of their common intention, took the deceased boys and murdered them. Thus, all the circumstances appearing against the accused have successfully been proved. From the above circumstances, it is clearly established that the accused, along with his son, is the author of the crime.
So what is wrong in the judgment? Reasons have been assigned, evidence discussed. All the circumstances have been proved by the prosecution. Where is the wrong, according to you?
Lordship, PW 11, the last seen theory, she is not inquired their family. Accused family. ସେଦିନ ଯାଉଥିଲେ ଗାଁ ଛାଡିକିରି ସେତେବେଳେ ସେ ପଚାରିଲାନି ତାକୁ ତ ସେତେବେଳେ ସେ ଦେଖିଥିଲା ନା
Let them submit notes of argument. All right, Mr. Katke, you can submit a note of argument. Submit a note of argument because circumstances
There are enough
are making-
materials plus 2 kids have been killed brutally. It's a grotesque murder. Plus, PW 11 is the last seen theory that supports, and PW 12 and 14 they're leading to discovery. And also in the chemical exam report, blood has been found out from the wearing apparel of the accused.
And it matches the blood group of the deceased.
Yes, Lord. Human being. I will give a written note.
Orders reserved. Same will be open to the parties to file their respective written notes of submissions. We say within 1 week.
Item 31.
May I please, Your Lordship?
Yes.
The conviction under section 302 of the IPC sentenced to RI for life, and under section 498A of the IPC sentenced to RI for 3 years.
This matter went to the Supreme Court, is it?
Because the case was dismissed, my lord, on the ground of limitation, the matter was carried to the Honorable Apex Court, and thereafter the dismissal order was set aside and it remanded back for hearing by this Honorable Court. Now, this is a case where the prosecution case is that, my lord, on 6/11/2008 at about 3:30 p.m., this accused abused, assaulted his wife, dragged her towards his body, poured kerosene over her body and set her to ablaze, for which she sustained severe burn injuries on her body and was very serious. The informant took the deceased Vichitra, his mother, to the capital hospital for treatment. After coming to the spot, prior to the said incident, the accused was also torturing his wife both physically and mentally, and was also assaulting her very often. Informant reported the matter at the police station, investigated into the case, and after completion of investigation, the charge sheet was submitted, and the prosecution was launched. Now, my lord, here, before placing the reasonings that has been assigned by the London trial court, I would, with your lordship's kind permission, draw your lordship's attention to the evidences that has been adduced by the prosecution. Altogether, 21 witnesses have been examined. I beg to point out one thing, that there is no direct evidence to indicate that the accused before your lordship had set her afire, so far as the deceased is concerned. The case is based on the so-called statement given by the deceased when she was already burning, and subsequent statement to the son who is a witness.
The son is the informant also.
Informant, PW7. Now, before placing the reasonings, my lord, primarily your lordship will find, so far as the trial court is concerned, the trial court has relied upon the evidences of PW1, PW7, and PW17, and later on PW6 to sustain the conviction. Now, that reasoning starts from paragraph 15, page 25 of the paper book. But before I place the reasoning, may I just, with your lordship's kind permission, place, my lord, the depositions of the witnesses?
Yes, yes.
Because your lordship will find there is no direct material that I have set her affair. Maybe there are some material to indicate that we had dispute, we are quarreling with each other. But so far as this setting her affair is concerned, if it is not established by the prosecution, if your lordship will be satisfied, then it may be a case where she has committed suicide by setting her affair. And if that is the case, on suppose the prosecution having not come forward with any such material, a conviction either under 302 or even abatement of suicide is
Let's
sustainable.
read the son's deposition.
Pardon, your lordship?
We'll read the son's deposition.
My Lord, with your Lordship's kind permission, I will place from PW1 itself, but I will only place the relevant portions, not the entire deposition.
All right.
I am conscious of that, but I will not waste your Lordship's valuable time by placing everything.
All right.
My Lord, PW1 also happens to be the son of the accused.
Correct.
But there are three witnesses who are the children of the accused. PW1, PW7, PW17, your Lordship. Now, so far as this PW1 is concerned, your Lordship will find, he says in paragraph 2, line number 2, I was not present at the time of incident and had been to my school. When I returned, I found my mother had sustained burn injuries on her person and sleeping on the ground. Then,
next line is important, sir.
I also found the villagers assaulting my father. Well, I am not disputing that. Assaulting my father, the accused. My brother took my mother to Capital Hospital for a treatment. From Capital Hospital, my deceased mother was taken to SU Medical College and Hospital, Cuttack, where she died. This next line is relevant. My mother intimated me that the accused set fire on her. Now, this statement, your Lordship will read along with the statement of PW7 and PW17 also. I'll point out that this statement that the mother was in a position to say will be belied from the evidence of other witnesses also. Because I'll say that she was not able to speak. That is what the IO also has said. Prior to the incident, my mother was assaulted by my father accused very often. I came to the house at about 4:15 p.m. on the date of incident from my school. Incident took place at 3:30, your Lordship. My elder brother had been to his work and had not returned. My sister had not returned from school. Then the suggestions have been given. Then your Lordship will find towards the middle of paragraph 3, I cannot name the villagers who were assaulting my father on the date of incident and at what time. I had not right to intervene. The incident took place last year during the month of Kartik. I had not been either to Capital Hospital or to SU Medical College, Cuttack with my mother. But then he says, my brother's sister had accompanied my mother to the hospital along with the accused. About 2 female members had sat near my mother when I came from school and found her sleeping on the ground in our house. I cannot name them. My father takes liquor, assaults my mother very often. Every day he used to take liquor. It is not a fact that my mother had not told me. That suggestion has been given. Then your Lordship may kindly turn to PW2. He happens to be house. Then the next page, your Lordship will see, she has denied the suggestion that the deceased was shouting that the accused had set her afire. But that will be relevant in the context of PW3. I have no direct knowledge also about the incident, PW2 says. Then your Lordship will kindly turn to PW3. This evidence may be some kind of relevance so far the prosecution is concerned. And she happens to be the elder brother's wife, my lord. She says, my lord, may I place it, my lord? Yes, the relevant portion, paragraph 2, yes, towards the middle. Hearing halla, I woke up and went to the house of the deceased and found the deceased in a burning condition and was shouting that the accused set fire on her person. Many persons came there, tried to extinguish the fire. Your Lordship will also see the independent witnesses pressed into the case by the prosecution have not supported the prosecution case. The next page, your Lordship will see that is very relevant. Whether this statement of the PW3 can be accepted in the context of her admission in the cross-examination. My lord, your Lordship will see paragraph 3 from the top. I do not remember the date, year of the incident. Many persons were present in the house of the deceased at the time of incident, but I cannot name them. I also cannot say the exact number of persons present there. Then your Lordship may skip 2 lines. It is not a fact that the accused was not present in his house on the date of incident and had come to Bhubaneswar. There was land dispute between the brothers of the accused much prior to the incident. I do not pull on well with the accused as he always abuses me. So he has admitted that I do not pull on well with the accused because he always abuses me. Your Lordship will find so far this raging halla at the time of when she was burning, that accused set me affair, the deceased said, this is the only witness who has said this. My lord, so far as this case is concerned, and PW1 has said that after she came, he was intimated that the accused set him affair. These are the two pieces of evidence available. Now, your lordship will see the statement of other witnesses belies such a statement because PW2 has denied to have heard anything like that. She was declared hostile, nothing has been elicited. And PW3 says, I had animosity because accused used to abuse me quite often. Now, your lordship will see PW4 happens to be the nephew, appellant's nephew. He has been also declared hostile, your lordship, and nothing has been elicited by the prosecution so far the case is concerned. Rather, he has specifically said, denied the suggestion that he has heard anything like that sort at the time he reached the spot. PW5 happens to be, my lord, again the nephew, and he was also declared hostile by the prosecution.
All right.
And he has said one more important thing that your lordship will find in cross-examination, that I was never examined by the police in this case. PW, my lord, 6, who is a co-villager, he has also not highlighted anything so far the case is concerned, and he has said, I was never examined by the police. Now, PW7, this evidence becomes relevant because this is the evidence which has been relied upon by the London trial court while sustaining the conviction, and he happens to be the son of the accused appellant before your lordship. He says like this, your lordship, I am placing the paragraph 2 in extenso, but this your lordship will kindly appreciate the vis-a-vis the statement of PW1. The occurrence took place on 6/11/2008 at about 3:30 p.m. I was not present at the time of incident. While I was on my work, I got a message over phone that the accused had set fire to the person of my mother. I came and found my mother lying on the ground, sustaining burn injuries on her person. I, along with some of my villagers, took her to Capital Hospital for treatment. The Capital Hospital referred my mother to SU Medical College Hospital, Cuttack, for better treatment. Then your lordship will see, then she died, and she was, my lord, after being 2 days in hospital, she died. Paragraph 4, that is cross-examination, your lordship will see. I work in a furniture shop at Hanspal. I cannot name the persons who intimated me about the incident over phone. Though I was having a mobile phone, I cannot say its number, also the number of the person who sent me message to me. The contents of FIR, well, this is very relevant. The genesis of the prosecution case is the FIR. Your lordship may kindly see how the FIR has been drawn up. The contents of the FIR was dictated to me by the police at Capital Hospital, which I have written in the FIR, Exhibit 1. So the FIR is a dictation by the police, not by the informant PW7 himself. It is written by me. I have not mentioned in the FIR that somebody informed me that my mother had sustained burn injury on her person and that I was present at Hanspal at 3:30 p.m. I cannot say the names of persons who accompanied to Capital Hospital. The accused had also accompanied us to Capital Hospital in the auto rickshaw. I was examined by the police on the very day of incident. It is not a fact that I do not know anything about the incident. It is not a fact that the accused has not set fire to the person of my mother. Then your lordship may kindly turn to the evidence of PW8. PW8 happens to be the younger brother's wife. And PW8 also has been...
I think that last suggestion is also important, which he denies.
Yes, that suggestion is with regard to committing suicide.
Correct.
But I'm not disputing that by itself.
No, that is what you suggested when you opened your arguments. That one possibility is that she may have committed suicide.
That is true, but that will not establish the prosecution case itself unless the prosecution establishes.
Your alternative theory was that.
Unless
ultimately she's found dead in the house.
No one else in the house, in the bari.
So
in the bari, she was found dead in the bari, and the entire evidence is with regard to this statement that I was set fire by the accused, PW3. Then PW1 says that I was intimated that she was set fire by the accused. That your lordship will again see this PW8 says he was never examined by the police. Seizure witnesses 9 and 10 has not much relevance because they have said that we have just signed on papers, we do not know anything. Here your lordship will find major of the witnesses have not supported the case of the prosecution, including relatives. And PW3, who has supported the prosecution, is anemically disposed of. And she has admitted that she was being abused and they were anemically disposed of. And the other witnesses who supposedly said about the deceased raising a holla have not supported the prosecution case. So PW3 statement is to be also appreciated in the context of the statement of other witnesses also.
So there are only two possibilities. Either she set herself on fire, like you're trying to suggest, or somebody set her on fire, correct? There are only two possibilities. So if she did not commit suicide, then who else could have set her on fire?
No, my humble submission would be, if the prosecution has not been able to produce material, be it circumstantial or direct,
answer this.
to establish the guilt of...
Answer this question, sir. If it is not suicide, how did she die?
No, my submission would be, suicidal part suggestion by itself will not lead to the fact that the prosecution has established its case. Prosecution says that it's a case of murder. Prosecution doesn't say it's a case of suicide. So from the materials available on record, my lord, it is to be considered as to whether the prosecution has established the case or not. Your lordship will find there is no direct evidence so far as the case is concerned. It is only based on these statements which your lordship has seen can be accepted with a pinch of salt only because of the reason that PW3...
So children will themselves speak against the father. What is the motivation for children to speak against the father?
Children have not stated that the accused has said the deceased on fire.
Of course. In fact, repeated suggestions are given to the children in the cross-examination that your father did not set your mother on fire, to which they deny.
No, they have denied.
Yes. So the children need not speak against the father.
Your lordship may kindly see the exemption in chief. Whether the prosecution, the children have stated anywhere that
you gave suggestions to the children that your father did not set your mother on fire. Both the children have denied the suggestion.
But that is because of the fact that the prosecution case is that. But these suggestions and denial thereof...
You don't have to give a suggestion.
May I just humbly submit one thing? This suggestion and denial thereof will not establish the prosecution case.
It shows your line. See, your line of defense comes through your cross-examination.
Your lordship will see the statement of the IO, which is very relevant. Your lordship may kindly see the paper book, the statement of IO, that is PW 21. Your lordship may kindly see. That is that page. I'll just point out how the prosecution has miserably failed. A suggestion will not strengthen the prosecution case, my lord. Because I have given a suggestion with regard to the suicide theory, by itself will not establish the prosecution case unless the prosecution, through its evidence, bring home the charge of murder, my lord. But it's a specific case of the prosecution that I have committed murder of my wife. Your lordship will see PW 21, that is at page 86 of the paper book.
Yes.
Your lordship may kindly turn to page 11. The cross-examination part, I'll just point out, that is paragraph 11. Towards the middle portion, your lordship may kindly see.
Yes.
It is not a fact that Vichitra Ojha, that is the deceased, was able to talk and move.
Right.
That means she was not able to talk and move. She has also not stated anything to me by signal. Why I beg to point out this? The entire prosecution material is that she stated that the accused has set him on fire.
Sir. By the time this officer sees the disease, it's much later.
And that,
much later.
What was the condition also of the deceased at that time is not known, because the deceased was lying. That is the statement of PW 1, PW 7 and 17.
This does not improbabilize the deceased having generally said that she's burnt by the accused soon after she fell down.
PW 3 was.
Because there is a gap between that Yes.
The injured was very serious.
Yes, yes. By the
So
time she's
therefore-
brought there, correct. By the time she's brought to Capital Hospital, she's in no position to even talk. That is correct.
What's your defense with regard to the incident? What is the explanation being the husband? How the wife died?
My
What
lord,
are the
it is like
circumstances?
this. It is the defense witnesses examined have said that he was outside. After hearing the news, he came. He accompanied. That is the statement of the also children, that he accompanied the deceased, which will show one of the conduct of the accused also, to the Capital Hospital, so also to the SCB. That is the statement of the children, your lordship will see. So it is not that he has shied away from the responsibility. He has taken him, the deceased.
What evidence has been led to show that you are not present? Plea of alibi.
But that was plea of alibi will only come into picture after the prosecution establishes its case. If the prosecution establishes its case beyond reasonable doubt, then, my lord, the plea of alibi will come to dislodge the prosecution case. Now, here I am trying to impress upon your lordships that the prosecution has failed to establish its case. But there is no direct evidence. Whatever your lordship will find are only hearsay evidence, barring possibly the evidence of PW3, who says that I heard that this was saying that she was set afire by the accused. And that cannot be accepted on the face of it, but the other related witnesses have stated that they have not heard anything like that. And that PW3 has admitted during cross-examination that she was inimically disposed of because she used to be abused by the accused quite often. That is what she has admitted during cross-examination. So here is a case where your lordship will see it is not a case of somebody seeing that directly the accused set afire the deceased. It is a case where everybody has come post facto the occurrence, and my lord, post facto the occurrence, the only deposition that comes into picture is PW3. PW3 has said that I am inimically disposed of. So whether that can form the basis of conviction, that is what I beg to point out. Your lordship will see what, my lord, these contradictions which I was pointing out to your lordship, my lord, so far as PW17, your lordship may kindly see, PW17, the child witness which is being relied upon being the child of the accused appellant, he says, I was never examined by the police. Your lordship may kindly see the paperwork, paragraph 5, PW17. But that is, my lord, in my humble submission, hazardous to the prosecution case, where prosecution relies upon PW1, PW7, PW17, and says that they are the children, so therefore their case, their version should be accepted. The child says, I was never examined by the police, and she is a child witness. She has been put to cross-examination regarding her ballot capacity, and she has given statements which are not coherent. Even he doesn't know the name of the headmaster or anything. He was put to in cross-examination, your lordship. So this PW17, in my humble submission, cannot be relied upon in any sense. And furthermore, he has not said that he has seen anything or heard anything from the mother. He has said he heard it from the neighbor. None of the neighbor who have been examined have supported the prosecution case, your lordship. So this is the background of the case. My humble submission would be that suspicion, howsoever grave it is, cannot form the basis of conviction unless, my lord, it is clinchingly the prosecution has been able to establish beyond reasonable doubt that this, because this is a case of murder, that is what the prosecution is putting forth, and the consequence is very harsh. And so far as this 498 part is concerned, my lord, there are materials to indicate that yes, there was some kind of quarrel and some kind of beating up. But so far as this murder part is concerned, in my humble submission, the prosecution has not been able to establish, my lord.
All right. Yes, Mr. Khatri.
There are clinching materials against the accused. I am reading plus the evidence of PW3, of course, up to certain extent, my lord and has read that statement. I'd like to draw lordship's attention to page 51. Cross-examination of PW3. I'm reading from the beginning, laws, because it is also coming under the purview of section 6 of the Evidence Act.
Yes.
Hearing Halla, I woke up and went to the house of deceased and found the deceased in a burning condition and was shouting that accused set fire on her person. Many persons came there and tried to extinguish the fire. Thereafter, she was taken to hospital. Plus cross. I don't remember the date here of the incident. Many persons were present in the house of the deceased at the time of incident, but I can name them. I also can say the exact number of persons present there. My house is at the backside of the house of deceased. There is only one road to approach the village road from the house of the village. It is not a fact that the accused was not present in his house on the date of incident and had come to Bhubaneswar. It is taking the plea of alibi. There was a land dispute between the brothers of accused much prior to the incident. I do not pull on bail with accused as he always abuses me. Here my line and friend has stopped. Next line is, it is not a fact that the accused is in no way involved in this case and I am deposing falsehood against him as I do not pull on bail with him. So denied. And then was it is not a fact that I am deposing falsehood against the accused. Reading the statement of PW1 along with PW3 and so also PW7 leads to an irresistible conclusion that it is only the accused who has committed the crime.
Yes.
Suggestion the witness has answered. Of course, my lord has already got it. My father takes liquor and assaults my mother very often. Every day he used to take liquor. It is not a fact that my mother had not told me that accused had set fire on her person. Then I'm coming to PW7's evidence. No, it starts on page 58.
Yes. This is the another son, informant.
Yes, I came and found my mother lying on the ground, sustaining burn injuries on her person. On the next page, page 59, paragraph 3, last portion. Prior to the incident, the accused was in the habit of quarreling with my mother and very often assaulted her. Then I am reading the cross-examination as a whole, with your lordship's permission.
Yes.
I work in a furniture shop. Yes. At Hanspal. I can't say the name of the person who intimated me about the incident over phone, though I was having a mobile phone. I can't say its number also, the number of the person who sent the message to me. The contents of the FIR was dictated to me by the police at Capital Hospital, which I have written in the FIR. Then it is written by me. I have not mentioned in the FIR that somebody informed me that my mother had sustained one injury on her person and that I was present at Hanspal at 3:30 p.m. So I can say the names of persons who had accompanied to Capital Hospital. The accused had also accompanied us to Capital Hospital. In the auto rickshaw, I was examined by police on the very day of the incident. It is not a fact that I don't know anything about the incident. It is not a fact that the accused had not set fire to the person of my mother. Though there was quarrel between deceased and accused on many occasions prior to the incident, I can't say about the cause of the quarrel. The quarrel between my mother and father was taking place regarding payment of money by my father as he had sold some landed property. It is not a fact that my deceased mother was also threatening my father that unless he pays back his money, he would die. It is not a fact that my mother committed suicide by burning herself. Already lost was got it lost by pouring kerosene on her body as my father didn't pay her money. I am taking a lordship directly to the defense witnesses loss.
No, but there is one criticism that he made that this person admits to police dictating the FIR.
Yes. Yes. He is a boy of 16 years at that point of time. Dictated, you lost me, I'll come to the FIR itself. I'm taking loss with the FIR. That cannot demolish the entire prosecution case. Because he is a carpenter, he was carpentry, he knows carpentry work. And regarding writing the FIR, he has to take the help of somebody else. And he has taken his help and he has written it. But the entire fact has been put to him and he has stated it's not a fact.
All right.
And the other aspect, the defense has been laid in a way you'll also appreciate. And one thing, so far as the evidence of PW3 is concerned, that has not been confronted to the IO. No question has been put. on the entire statement of PW3. That your lordship will examine, right? It starts from page 86. And at page 88, paragraph 4, I have examined Mushi Oza, PW2, who was first on hostile. He has stated before me that on the date of incident, the accused was assaulting the deceased and she was shouting that the accused had set fire on her person. Then regarding PW3, nothing lost. No confirmation. And regarding the place where the dead body was found, it is only his house, because I am now reading the defense witnesses. 92, page 92, that is DW1. I know the accused in the duck, who is my co-villager, and also know his family members. My house is adjacent to the house of the accused. On the date of incident, I was present in my house. I have never come across with any quarrel between the accused and his wife at any point of time for the last 20 years. The deceased Vichitra Oza died due to burn injuries on her person. I can't say how and under what circumstances she died due to burn injuries on her person. By the time I arrived at the spot, I found her entire body was burning. The accused was as a mason, comes to Bhubaneswar on his work. For a moment, I am taking loss to DW2, page 94. Multiple pleas have been taken loss. I am reading from paragraph 2. On 6th November 2008 at 3:30 p.m., I was present in the village. I heard halla in the house of accused on that day. My house is adjacent to the house of the accused. When I arrived at the house of the accused, I found bodily injuries on the person of Vichitra Oza and a bedsheet was covered on her body. Except Vichitra Oza, none else was present in his house, and accused had been to Cuttack Road in his work. Plus here, a plea of alibi is being taken. The informant had been to Rasulgod to work, and his sister had been to her school. Then paragraph 3, Vichitra Oza sustained burn injuries on her person as kerosene was poured on her body. I do not know who had poured kerosene on her body. As I arrived there, after she had sustained burn injuries on her person, Vichitra Oza, prior to her death, was behaving as a mentally retired woman. This is another plea loss. And DW3, paragraph 2, I am coming last 3 lines, I am reading loss. Prior to the incident, Vichitra Oza was behaving abnormally due to mental retardation. The accused and Vichitra Oza were pulling on bell. So taking multiple pleas, even if no suggestions have been put to the witnesses, taking multiple pleas means each plea is false. So taking a false plea is another circumstance against the accused.
Right.
And here, regarding the conduct of the accused, as my learned friend has pointed out, because he accompanied the dead body, accompanied the body to the hospital, he didn't have any other option because he was controlled by the villagers. And some villagers also have assaulted him. In order he is a good man, he was being assaulted because he did some work for which he was being punished by the villagers. Because he burnt her, his wife to death. And PW3's evidence loss, I was citing a judgment in earlier case, that is Ratan Singh's judgment that is covered, that is admissible under section 6 of the Evidence Act. My learned friend was submitting that it is not admissible because it's a hearsay evidence. Because that person is no more available, who has stated that my husband has set me on fire. And setting a fire, what my learned friend has submitted, that in body or in house, because a person when will be set on fire, she cannot be and it is a question of appreciation before the before this appellate court laws.
Right.
Here, whether there lies a ring of truth in the evidence led by the prosecution. Here, the question is when the PW3 is stating that yes, I have heard the deceased saying that yes, my husband has poured kerosene on me and set me on fire. That is admissible. That is a contemporaneous statement. That is to the fact in issue. Because the issue is whether the victim has been killed by her husband, being burned to death or not. So there, her statement is very much important. So under section 6(1) as well as section 32(1) of the Evidence Act, that statement is admissible and that is a substantive evidence, as has been said by Honorable Apex Court. For a moment, just I am reminding Lordship that judgment Ratan Singh versus State of UP, that In either case, whether it is admissible under section 32(1) or under section 6 of the Evidence Act, it is substantive evidence which can be acted upon with or without corroboration in finding guilt of the deceased. Here the defense plea even is against him because the dead body has been found in his house and has been found dead, and also, and as your lordship has rightly pointed out, because son is own kids are coming up to tell against that accused. So that is the conduct of the accused. That shows. So the prosecution has proved this case beyond all reasonable doubt. He is only the person who has been
I'll just clarify a little bit. My lordship, in fact, posing a question to my learned friend is as to whether the very genesis of the prosecution, the fact that the IO has dictated the FIR, whether the genesis of the prosecution is vitiated or not. That is what your lordship.
Even the FIR goes, I'll just show you lordship. Even the FIR goes.
If my friend
then,
then I can just answer.
What my learned friend
If
say?
my friend, I'll just answer a little bit. I am not at loggerhead with my friend. I am just assisting your lordship to arrive at a just conclusion. My lordship was pleased to ask him as to whether this genesis of the prosecution goes. My friend says if the genesis also goes, still then the conviction can be sustained. I think such a proposition is not permissible in law. Here, your lordship, I was pointing out to your lordship that this is a case, this theory of murder by the accused is very set up by the police himself, because the police has dictated the FIR and any witness, those who are available, have not supported. Now, one more thing, my friend was trying to point out that to the IO regarding PW3, no suggestion has been given. Your lordship may kindly see the examination in chief. IO has not even said that he has examined PW3. So, question of giving a suggestion would not have arisen.
It is confrontation. It's not suggestion. I think
my friend should not give piecemeal reply. I'm just assisting your lordship. I didn't disturb him when my friend was making submission. My lord, what I beg to point out, when the IO has not said anything about PW3 or her statement before him, question of giving a suggestion to him in cross-examination would not have arisen. Now, my friend extensively relies upon the defense plea to say that because I have taken prevaricating defense plea, so the prosecution case is established. My humble submission would be that by itself will not be ground. Still then, this being a case of 302, the prosecution has to establish with clear clinching evidence beyond reasonable doubt that I have committed the murder of the deceased, weeding out any sort of doubt that is possible. So it is not a case that by taking that I have failed my defense plea, so therefore defense plea only will come when the prosecution has established the case. I have submitted it for a lordship. So therefore, defense plea, even if it fails, the prosecution having not established the case cannot say that the 302, so far as 302 is concerned, it is sustainable. Now, so far as the other materials are concerned, so section 6, my friend was taking aid of on 32. That will only come. He was saying that PW3, before he heard that the deceased said that she was set fire. Yes, it will come with either within the purview of section 32 or section 6 of the Evidence Act, provided the precondition of this part of the statement being believable beyond reasonable doubt is established. And this is the only witness who has said that she heard this and she has said she is animically disposed of. Now a suggestion is taken aid of to say that she has denied the suggestion because she has animically disposed of, she has falsely implicated. That suggestion has been given because I have to give that suggestion that she has falsely implicated me. So merely because she denies that suggestion by itself doesn't make her statement pure, because she has admitted that I am animically disposed of, I am being abused by the accused time and again. Other witnesses who are also related, staying nearby, have come, have disowned the statement, have said that the police has never examined me. When the genesis of the prosecution itself is very doubtful, namely the police has dictated the FIR and it is being admitted. So therefore the entire thing is shrouded with mystery because the relatives also have disowned. Relatives have not supported. Independent witnesses, whosoever has been pressed into service by the prosecution, have not supported the prosecution version. So in this background, my humble submission would be that the prosecution has failed to establish the case beyond reasonable doubt. So therefore, so far as at least 302 is concerned, the prosecution has not been able to establish. So there may be some kind of material to say with regard to the torture prefect to the death of the deceased, which may bring home the charge so far as 498 is concerned. And he's already in custody for, I think, 13 years, more than 13 years.
Or yes, one judgment I am just citing.
You can put it in a note. You can put it in a note, sir.
I'll give you.
May I
Only
also-
three
Yes.
paragraphs with the Lord's permission, may I read?
You all right.
There is a 2010 volume 12 SCC 320 page 324 State of UP versus Krishna Master. Before appreciating evidence of the witness examined in the case, it would be instructive to refer to the criteria for appreciation of oral evidence. While appreciating the evidence of a witness, the approach must be whether the evidence of the witness read as a whole appears to have a ring of truth. Once that impression is found, it is undoubtedly necessary for the court to scrutinize the evidence more particularly, keeping in view the deficiencies, drawbacks, and infirmities pointed out in the evidence as a whole and evaluate them to find out whether it is against the general tenor of the evidence and whether the earlier evaluation of the evidence is second as to render it unworthy of belief. Minor discrepancies on trivial matters not touching the core of the case. Hyper-technical approach by taking sentences torn out of the context here or there from the evidence, attaching importance to some technical error committed by the investigating officer, not going to the root of the matter, would not ordinarily permit rejection of the evidence as a whole. If the court before whom the witness give evidence had the opportunity to form the opinion about the general tenor of the evidence given by the witness, the appellate court, which had not this benefit, will have to attach due weight to the appreciation of evidence by the trial court, and unless the reasons are weighty and formidable, it would not be proper for the appellate court to reject the evidence on the ground of variations or infirmities in the matter of trivial details. Minor omissions in the police statements are never considered to be fatal. The statements given by the witness before the police are meant to be brief statements and could not take place of evidence in the court. Small trivial omissions would not justify a finding by court that the witnesses concerned are liars. The prosecution evidence may suffer from inconsistencies here and discrepancies there, but that is a shortcoming from which no criminal case is free. The main thing is to be seen is whether those inconsistencies go to the root of the matter or pertain to insignificant
This is all well
aspects.
settled, Mr. Gatke.
Yes, yes.
These
That-
are settled
and
problems.
Paragraph 17, 2 lines plus. In the deposition of witnesses, there are always normal discrepancies, however honest and truthful they may be. The discrepancies are due to normal errors of observation, normal errors of memory, due to lapse of time, due to mental deposition. So it's 15, 16, and 17 was again. I will also give a
Citations are to be understood in the context of the fact of the case.
All right. Orders reserved. Both parties are permitted to file their respective written notes of arguments within 1 week.
Obliged.
Weekly list, old matter, item number 1.
One, my lord, may I pray, my lord? I pray for an adjournment so far this matter is concerned. I have other matters, my lord. And I was ready in the other matters which I have argued. One, my
It will stay on board, sir. It will stay on board.
my lord, not, but I only pray, my lord, not on 14th.
Let's see, sir. There is also a date in between.
It's a 2 weeks after, my lord. I pray 2 weeks because I have other 3 matters, my lord. My associates are ready. Only one, my lord.
It's okay. Then let it stay on board, sir. Let it stay on board. Right.
Item number 2.
14th, I have some problem. Next week.
We are accommodating you, sir, anyway. So, provided you argue other matters, we'll
I'm
accommodate you in this.
I'm obliged.
Weekly list, item number 2.
Item 2, I am praying for an adjournment, your lords.
Why, sir?
My senior is ill.
Who's your senior, sir?
Mr. Sangram Jitkonda.
All right. All right. It will stay on board, sir.
Weekly list, item number 3.
On the 3, 7, and 8, let him stay on boards. This is 350, my lord. Your lordship this may stay on boards, my lord. Next. It's already 350. 3, 7, 8.
All right. You are waiting for which matter, sir?
We are on item 15 last.
If you're ready, we can go.
We'll take some time. If your lordship permits, we can start.
Yeah, if 45 minutes is enough, no?
Yeah, no, not enough. Mr. Khurshid is also.
You know, this is that same matter.
Yes, that Dakkati murder. So it has been heard finally. Anyway, all the notes and everything is there. Only few witnesses and 2 eyewitnesses only.
Right.
So if your lordships permits me, then I'll tell them to appear on these.
Okay. Anyone else in any other matter? You wanted item 10, you wanted to appear.
My senior is appearing, he is authorized to submit statement, madam.
Who's your senior, sir?
Prasant Kumar Mahanti.
So where is he?
He is ill, my lord, today, therefore he has entrusted the brief to me to place before you.
If you're ready, it's a big opportunity for you to argue, sir.
My lord. Item 10.
Go ahead. If you're prepared, go ahead, sir.
My lord. My lord, this case is based upon the direct evidence. And the prosecution, my lord, examined 11 witnesses to this case.
1 minute. Mr. Panda, you're ready in some matter.
My lord, I am waiting. If my matter reaches, I'll have to do it.
Then do it because getting you is difficult.
But my difficulty, my lord, is that a junior will lose the opportunity of arguing before your lordship if your lordship takes up.
That's okay. He's not so confident. So, all right.
I mean, item number 5 minutes.
Yes. Tell us.
Lords, in item 5,
yes,
the incident happened on the night of 1/3/2002.
Right.
And it arose because of a previous incident which occurred on 28/2/2002.
Yes.
8 accused persons faced trial, my lords, before the Court of Sessions.
Yes.
And they were charged under various sections. They are at page 31 of the paper book, your lordship may see. The 8 accused were charged firstly under section 147A. The second charge was under 341 read with 149.
Yeah.
The third charge was under section 323 read with 149.
Right.
Fourth charge is under 324 read with 149. And the fifth charge, my lords, is under 302 read with 149.
Yes.
One thing your lordship will note, there is no charge framed under section 148 of the IPC.
Right.
Now, my lords, these are the only 8 persons against whom information was lodged, and there are no others. Now, would your lordship look at the impugned judgment, which is at page 61 of the paper book.
Yes.
The judgment is dated 28/10/2003.
Right.
Accused and charged on sections 147, 341 by 149, 323 by 149, 324 by 149, 302 by 149 IPC on the allegation of having formed an unlawful assembly on 1/3/2002 at about, that time is somehow obliterated. It will be sometime in the night, 8:15 p.m. at village Ratnapur, and in prosecution of the common object of such unlawful assembly, to have wrongfully restrained the deceased Biranchi and his brother Robby, and also to have assaulted them, and ultimately to have committed murder of deceased Biranchi. Robby is PW4, the eyewitness, my lords.
Right.
Then I am only placing the prosecution story in the next paragraph for your lordship's appreciation.
Yes.
He writes, deceased Biranchi and his brother Robbie, PW4 informant, with others had grown watermelon at village Ratanpur, and the respective cultivators were keeping watch over it. On 28/2/2002 midnight, accused Ekadasiya, he was the accused number 7 in the trial, my lords.
Yes, Doshi alias. Right.
Yes, had entered inside the watermelon field of the informant Robbie for committing theft. Now your lordship will mark, accused 7 had entered into the watermelon field of PW4 for committing theft, but the same was witnessed by Sibo and Bellal Sensa. They are PWs 1 and 3. They are witnesses to the theft allegedly committed in the previous night in the watermelon field of PW4 by accused 7, at whose instance Ekadasiya fled away. On 1/3/2002 morning at 7 a.m., Ekadasiya came to PWs 1 and 3 and rebuked them in obscene language, which was subsided by the deceased Biranchi. In the same night at about 8:15 p.m., while informant Robbie was returning to his house from the watermelon field, all the accused, being armed with lathis, tangia and knife, wrongfully restrained him and attacked, for which he shouted for help. And hearing the same, deceased Biranchi came running, followed by his wife Subhasini and son Pratap, while PWs 1 and 3 also came running from the watermelon field. On the intervention of deceased Biranchi, appellant 1 Rajkishore dealt an axe blow to him, while accused Ramani, his appellant 2, stabbed him by a knife, while others assaulted him by lathis. When informant Robbie came to the rescue of the deceased Biranchi, accused Bennu stabbed him by knife. Biranchi, due to the axe and knife blows on his head and chest, sustained severe bleeding and fell down, for which he was taken to District Headquarters Hospital, Devgarh, where in course of treatment he succumbed to the injuries on the following morning, that is on 2/3/2002, and thereafter FIR was launched. Now, my lords.
Yes.
I placed the charges before your lordship.
Correct.
My first submission is that there is no charge under section 148. My second submission is that there is no substantive charge against any of the accused persons, either under section 323 or 324, 341 or 302 of the IPC. Learned Sessions Judge, my lords, after recording of evidence, my lords, framed the following questions there at page 12 of the paper book at paragraph 4.
Yes.
He says, it is therefore to be determined whether on 1/3/2002 at about 8:15 p.m., accused had formed an unlawful assembly, being armed with lathis, tangia and knife at village Ratanpur. Second is whether the accused in prosecution of the common object of such assembly wrongfully restrained informant Robbie and his brother Biranchi, that is PW4 and the deceased. Whether accused in prosecution of the common object of such assembly caused hurt to the informant Robbie and his brother Biranchi by inflicting lathi blows. Then says whether the accused in prosecution of the common object of such assembly inflicted knife and axe blows upon informant Robbie and his brother Biranchi, causing injuries. And the last question he framed was whether the present appellants, that is Rajkishore and Ramani, in prosecution of the common object of such assembly, inflicted axe and knife blows on the deceased Biranchi with intent to cause his death, which resulted in his death. Lords, Another thing your lordship will mark is there is no charge on section 34 of the Act. The learned Sessions Judge Millards, at page 15 of the paper book, your lordship may see 6 lines from the top. He comes to the conclusion that with evidence on record establishes that PWs 1, 2, 3, and 4 have categorically stated that accused Ramani stabbed a knife on the chest of the deceased Biranchi, accused Rajkishore dealt an axe blow on the head of deceased Biranchi, while others assaulted him by lathis. Their evidence further goes to show that when PW4 came to the rescue of his brother and intervened, accused Bennu dealt a knife blow on his head. After coming to this conclusion, my lords, now your lordship may look at page 20 of the paper book, the conclusion of the learned judge. Paragraph 20 at page 20 may be seen.
In the present case?
Yes. In the present case, accused Ekadasya was apprehended when he attempted to commit theft of watermelons in the night of 28 to 2002. For that, he rebuked PWs 1 and 3 in the following morning, which had been subsided by deceased Biranchi. And due to grudge, Ekadasya with the other accused, being armed with knife, axe, and lathis, have formed an unlawful assembly on 1/3/2002 night at about 8:15 p.m., obstructed the informant Robbie while he was coming to his house for taking food, and on his shouting for help, when the deceased Biranchi came to his rescue, he was brutally assaulted by the accused, out of whom Ramani stabbed by knife on the chest, Rajkishore inflicted axe blow on the head, which resulted in his death in the district headquarters hospital, Devgarh, on the following morning. The sequence of events thus clearly establishes that Ramani and Rajkishore, with intent to kill the deceased, Biranchi inflicted the knife and axe blows upon him. It is thus a clean case of murder by accused Ramani and Rajkishore. So he eliminates in this conclusion that there was a common object of the entire assembly of 8 persons. He fixes the liability for murder, my lords, on the 2 appellants, and then he says, considering all these facts and circumstances of the case as discussed above, I thus come to the finding that on 1/3/2002 night, at about 8:15 p.m., all the accused, except accused Budhu Penthei, against him no evidence was laid, were members of an unlawful assembly. And in prosecution of common object of such unlawful assembly, they wrongfully restrained the informant Robbie and the deceased Biranchi. Accused Ramani and Rajkishore inflicted knife and axe blows on the chest and head of Biranchi with intent to kill him, while others dealt lathi blows on him, and accused Bennu inflicted knife blow on the head of the informant Robbie. Again, my lords, it says that there was a common object and there was an unlawful assembly. But what does he say at para 22? In the result, while acquitting Budhu Penthei from all the charges, Rajkishore and Ramani are held guilty of the offences under section 147, 341 by 149, and 302 by 149 IPC. Lords, how can 2 persons out of 8 be held guilty of an offence under section with the aid of section 149? Then he says, Bennu is held guilty under 147, 341 read with 149, and 324 read with 149. And he says, Ekadasya, Jagannath, Purna, and Kaliya are found guilty under 147, 341 by 149, and 323 by 149, and convicts them, my lord. My lord, so the common object of the unlawful assembly, as found out by the sessions judge, is one of wrongful restraint only. He convicts all of them under sections 341 read with 149. But my respectful submission, Milords, is that he could not have convicted these two appellants, Milords, with the aid of under section 302 read with 149, excluding the other accused persons, Milords. That is because, Milords, I'll ask your Lordships to look at the penal code. There is a distinction, Milords.
The fact that the prosecution did not appeal against their acquittal will not mean that you're not an accused.
They don't do that, Milords. They don't read between
that by no means helps you, Mr. Panda.
It helps me, Milords. It helps me because, Milords, no conviction of the appellants can be sustainable under 302 read with 149 when the others have been acquitted thereunder. Would your Lordship look at chapter 8 of the IPC?
Yes, we have
Section
that.
141.
Yes.
Unlawful assembly. An assembly of 5 or more persons is designated an unlawful assembly if the common object of the persons composing that assembly is, we are not concerned with the first one. The second and third are to resist the execution of any law or legal process, we are not concerned. The third one is to commit a mischief of criminal trespass or other offense. Fourth is by means of criminal force or show of criminal force to any person to take or obtain possession of any property or to deprive any person of the enjoyment of a right of way, we are not concerned. Fifth is by means of criminal force or show of criminal force to compel a person to do what he is not legally bound.
Third is always there. Third is always there.
Yes.
To commit any mischief or criminal or other offense. Yes.
Now, your Lordship, section 147 of the IPC. Section 147 is a distinct offense. It prescribes the punishment of rioting, which is defined in 146. 148, Milords, is the punishment for rioting armed with deadly weapons. I am said to have held an axe and a tangia, Milords. There is no charge framed against me under 148 IPC.
Right.
Then, Milords, section 149. Every member of an unlawful assembly guilty of offence committed in prosecution of common object. 149, Milords, makes out a distinct offence, which section 34 does not. 34 deals with common intention, whereas 149 is a distinct offence of being a member of an unlawful assembly and thereby being guilty of an offence. Now, Milords, a small judgment can I share with your Lordships, Milords, if your Lordship permits me to share the screen?
Yes, yes.
Because it is not reported in SCC. I collected it from the Supreme Court site, Milords.
Yes.
That was a conviction under section 325 read with 149, Milords.
Right. Permit sharing, sir.
Yes.
Yes, Mr. Panda. Yes, Mr. Panda. You can share it now.
Just a minute. But while it is being uploaded, my lords, I have got only.
Yes.
My submission before your lordship in effect is, my lords,
yes,
that the conviction of a person of having committed a substantive offence with the aid of 149 is only permissible when there are 5 or more persons.
Right.
Such conviction is permissible in case of, my lords, persons who face trial, whereas others have not faced trial, when the prosecution case is that X and Y, along with others, my lords, were members of the unlawful assembly. They may be named.
Mr. Panda, your argument would be very strong if none of the other accused got convicted of anything whatsoever.
No, my lords, my submission is that this conviction is
1 minute.
not sustainable.
No, 1 minute. It's not as if only these two have been convicted of any offense at all, and the other accused have all got scot-free. It's not like that. All of them have got convicted of some offense read with 149 because they all did come with a common object. The only distinction is the acts performed by each of them, for which they meet different consequences. 149 is valid for all of them. They all come together with that common object, so they've all got convicted, but for different offenses read with 149.
Offense or not, I will be liable.
Our turn now. Then it's held up well for the whole day.
And the charge is only under section 302 with 149 against these appellants, my lords. That conviction is not sustainable. Your lordship may look at the judgment which I am placing, page 2 of the judgment, the last paragraph.
Yes.
The court writes like, it may be relevant to note that the charge sheet was filed implicating 20 accused who faced trial, and the learned trial court acquitted 17 out of 20 who faced trial, and 3 were finally convicted under 148, 325 read with 149, and 323 read with 149 IPC. It may be relevant to note that one of the accused who was convicted, Sardar Singh, expired during pendency of the criminal revision, and qua him the revision was dismissed as having been abated. Then your lordship may see, omit the next paragraph. The paragraph begins, counsel for appellant submits that the charge sheet was originally filed against 20 persons, and all of them faced trial, and 17 out of 20 were acquitted by the trial court by judgment dated such and such. No further appeal revision was preferred by the prosecution against the judgment of acquittal passed by the trial court against those 17 accused who faced trial.
Completely acquitted.
And 3 out of 20 were convicted for the offences under section 148, 325, and 323 read with 149. And it is not the case of the prosecution who could not be traced to be charged for appellant submit ingredients of section 149, it must be 5 or more, which out of 20 accused who face trial, 3 have been convicted by the learned judgment dated such and such. Under sections 148, 325 read with 149, and 323 read with 149 IPC. And the essential condition of unlawful persons as contemplated under section 141. Counsel submits that conviction under the impugned judgment of appellants under section 325 with the aid of 149 is unsustainable. Respondent while supporting the judgment impugned submits that 20 were charged who faced trial, and thus merely because final conviction was of 3 accused and 325, with the aid of 149 IPC, requirement the court below on merits, upholding conviction, it needs no interference. Now, my lords may see at page 5 what their lordship say. A constructive criminal liability for all members of an unlawful assembly, where an offence is committed by any member of such an unlawful assembly in prosecution due to be likely to be committed in prosecution of that. And here the trial court has categorically concluded that the common object of the assembly was one of wrongful. It is another matter, my lords, that one was acquitted and the rest 5 have had their convictions, have completed their and gone out, my lords. But what notice that the essential ingredients must have been committed by lords. I was discussing.
Yes, Mr. Panda.
The essential ingredients of 149 are that the offence must have been committed by any member of an unlawful assembly. And 141 makes it clear that it is only for 5 or more persons constituted an assembly that an unlawful assembly is born, provided, of course, the object of the persons comprising that. Same time, it may not be necessary
Mr. Panda, we are not able to hear you.
before the court and less than
This is what he's trying to
six in the second paragraph of the Lordships. The Lordships say, however, in the instant claimant and 302 have been acquitted, they are not convicted thereunder. How can the conviction of these two appellants be sustainable under 302 read with 149?
All right. All right. Can you take us to the last page of the judgment?
Yes, my lords. From page 6, my lords, the last paragraph I am placing. Appellants may be held responsible for the offence, if any, which could be shown to have been committed by them with regard to participation of others. But that was not the case of the prosecution. In the given facts and circumstances, in our considered view, conviction of the present appellants on section 325 with the aid of section 149 IPC at least would not have been invoked. That apart, appellants have also undergone 3 months of substantive sentence. Then their lordships say, consequently, the appeal succeeds and is accordingly allowed. Judgment of the trial court dated 12/11/2008, convicting appellants on section 148, 325 read with 149 and 323 read with 149, which came to be confirmed by the High Court, is hereby quashed and set aside. Now, what I would like to submit before your lordships is this. Now, section 34, my lords, your lordships know the celebrated case of Barendra Kumar Ghosh versus King Emperor. When a charge is there under 34, their lordships of the Privy Council said they also serve those who stand and wait, and so convicted the Barendra Ghosh who was standing outside the post office with the aid of section 34, though no overt act was said to have been committed by him. But that cannot be when a charge is under the substantive offense read with 149. And here there being no separate charge under 302, simpliciter, my lords, no charge under 148. That is that I have committed rioting being armed with deadly weapons. This conviction is not persons are concerned. But here it's a case where there were 8 people, of whom one was acquitted by the trial court. It is not the prosecution case that these 8 and others were there. It is not the prosecution case that apart from the acquitted accused persons, there were others who shared the common intention of murder. And Ekadasya, who is the person aggrieved, He has been acquitted, Millards. The entire incident
The trial judge.
because from the information
So Mr. Panda will continue next week, next Thursday. I'm sure you will come up with renewed ammunition with more case law.
we shall.
Mr. Panda will continue next
Examination is
Thursday.
sufficient.
Next
I don't
Thursday,
think
can we
I
continue?
do anything more. Right, Miller?
Mr. Katkia? Who's here there? Mr. Mudali is here. All right. So next Thursday we'll continue. We'll continue next Thursday. All right.
Item 50.
That will stay on board, sir.
What we are praying is that can it be on the supplementary list so that you've taken up? So it is running in the board, so it is difficult.
We don't know who's ready, who's not.
No, we are ready in that matter.
That you're saying it now. If you had told us this morning, we would have taken it up straight away.
All right.
The whole of the morning we're waiting, trying to get lawyers to argue.
No, it's next Thursday, then we'll.
None of them is ready to argue, as you can see.
No, we are ready. Well, next Thursday, I'll mention it in the morning.
My
lords. Grateful.
All right.
One.